Yes. Item number 1 from appellate side, daily cause list.
Yes. The petitioner before your lordship is the marginal farmer, my lord. He was the member of a particular cooperative Kisi Samawai cooperative society, my lord. And in the year 2007, my lord, he took loan from the Samiti, and thereafter it was, my lord, unpaid and was due, my lord. But thereafter, my lord, in 2008, the government of India introduced a scheme for waiver scheme, my lord, as regards to the interest and, my lord, some principal amount, my lord. My lord, I have here, my lord, the challenge, the notice issued by the, my lord, the Cooperative Unnayan Samiti Limited. My lord, here, my lord, the scheme has not been considered by the, my lord, the Samiti, my lord. Although, my lord, there is a scheme of the government of India, the finance department, my lord. My lord, here in the scheme, my lord, in clause 2, it has been specifically stated the entire applicable interest on the investment loan that is overdue as on December.
Notice upon Bankura Central Cooperative Bank Limited.
My lord,
Nobody
at
is
that point of
representing
time, my lord, I have, my lord, served, and
Now
everybody.
you have to serve
My lord,
another
again, my
notice.
lord, then I have to, I mean, since long time this matter could not be, my lord, reached, my lord. Only, my lord, I am praying that whether the scheme will applicable in my case or not.
You also amend the presentation form. This Panchayat, why you have filed the writ petition describing the writ petition as a Panchayat matter. Video of last order passed by this court on 19th September 2023. The learned advocate for the petitioner was granted leave to amend the presentation.
My lord, I am the advocate, my lord, I am here now, my lord, I am ending the, my lord.
Leave is already granted.
My lord, my lord, I could
Amend
not
the
follow.
presentation form and serve notices upon the respondents. You are not appearing for the state respondents. Why? Because State of West Bengal Service to the Secretary, Department of Cooperative Cooperation, it should be Government of West Bengal.
আপনাকে দিয়ে দেবো?
And Bankura District Central, you have to serve notice.
My lord, my lord,
Assistant Register of Cooperative Society. So both of you are appearing. So therefore, you take steps, obtain instructions, and serve notice upon other authorities like Bankura District Central Cooperative Bank and come back.
Central Cooperative as well as, my lord, the Samiti, my lord, also need to be served.
The writ petition is heard in presence of, in terms of the order, heard in terms of the order dated 19th September 2023.
নামগুলো দিয়ে দে, তাহলে দিয়ে দিতে পারবো।
September 2023, when you are Mr. Moloy Bhattacharya,
My lord.
when Mr. Moloy Bhattacharya, learned advocate, appears for the petitioner, stop. Appears for the petitioner and makes submission. Stop. However, no one is representing the respondents today. Stop. Mr. Srijon Nayak, Mr. Srijon Nayak, learned advocate, and Mr. Sureka. Where is Mr. Sureka? Mr. Sureka, learned advocate, are requested to appear on behalf of
One
the
and
State
three.
of West Bengal, State of West Bengal Department of Cooperation, being respondent number 1, and Assistant Register of Cooperative Society, Bankura Range. It should be Bankura Range. Bankura Range, being respondent number 3. Stop. Stop. However, respondent number 2, 4, and 5 are required to be served Stop. The next paragraph, learned advocate representing the petitioner is directed to serve notice upon respondent number upon the non-appearing respondents being respondent number 2, 4, and 5.
4 and 5 is the same, my lord.
2, 4, and 5.
My lord.
Include 2, 4, and 5, enclosing copy of the order passed by this court today by by 5th October 2023 and file affidavit of service on the urgent date. Stop. List the matter for further consideration under the same heading on 11th October 2023. Next,
Malay Bhattacharya. My lord, earlier affidavit service be kept with the record.
it is of no use.
Very well, my lord. তোমাদের এগুলো দাম কপিগুলো দিই।
Item number 2.
Issue. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, respondent number 1 is represented by learned advocate. Stop. Stop. Previously, on 20th September 2023, the writ petition was taken up for consideration when accommodation was prayed for on behalf of the petitioner and same was granted. Thereby, matter was fixed for further consideration today, 27th September 2023. Stop. Next paragraph. 27 September 2023. Stop. Next paragraph. It appears that petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order stands vacated. Urging direct certificate copy. Next.
Lordship. But I am taking short leave, Lordship. Other matters here.
Item number 3.
Number 3, I am for the respondent number 5 and 6. As per the order dated 16th September 2022, passed by His Lordship Honorable Muhammad Nizamuddin, the writ petitioners were directed to file an affidavit in opposition to the can filed by the respondent number 5 and 6. But on 22nd March 2022, a stay order was passed against the respondent number 5 and 6 to give effect to the advertisement dated 18 January 2021. So, my lord, for vacating the stay order, an application being can number 4 was filed by respondent number 5 and 6, for which the petitioners told they will be giving an opposition, but they have not filed it till date, my lord.
Yes. Now, have you received any notice from the learned?
No, my lord, we have not received any notice.
No notice.
No notice. Was
You are representing 5 and 6.
5 and 6.
Issue. Writ petition is taken up for consideration when no one appears for the petitioner and no accommodation is prayed for. Stop. However, respondent number 2 to 6 are represented by learned advocates. Both of you are appearing, PK Rai and Unkit Sureka. And 5 and 6
5 and
are
6.
represented by learned advocates. Stop. Next paragraph. The writ petition was taken up for consideration previously on 13 September 2023, when accommodation was prayed for on behalf of the petitioner and the same was granted. Thereby, matter was fixed for further consideration today, 27th September 2023. Stop. Next paragraph, it appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order, if any, stands vacated. Stop. Application, comma, if any pending, stop, comma, also stands dismissed. Stop. Urgent Xerox certificate copy. Next.
Item number 4 to 6.
Mr. Shoykot Chatterjee is appearing for the bank, respondent bank, my lord.
What is the petitioner?
Lordship, Mr. Kishore Mukherjee is not being able to appear due to some personal difficulty. I humbly pray to your lordship.
Where is he?
Lordship, he is at home, lordship.
Where is he?
He's at home, lordship.
Why?
Lordship, he has fever, I suppose.
But the matter was taken up. It was
Yes,
considered.
lordship.
Today matter is due to be heard by this court.
Yes, lordship. I
Every
apologize.
day this sort of prayer cannot be entertained.
No, lordship, I understand.
It was earlier dismissed for default. Then on the prayer, oral prayer of the learned advocate representing the petitioner, it was restored.
Yes,
Thereby
lordship.
matter was fixed for consideration. Again, Mr. Mukherjee will pray for time,
Lo-
taking rest at home.
Lordship, he has fever.
We will pay cost to the respondents for 7 days, 70,000 rupees. I will fix the matter on next Wednesday. Every day, learned advocates
Lordship,
representing the respondents are appearing. This can't be
Lordship, may this be
tolerated
the last chance, lordship.
anymore. Sorry, pay cost of 70,000 rupees per 10,000 rupees per day. Ask your senior. This was dismissed for default.
Yes,
On
lordship.
his prayer, I restored the matter. Then matter was heard. He was present on last day.
Lordship, kindly keep it
What
to
is this?
Yes.
And what about the bank? Last occasion, bank also took time.
My lord,
Where is Mr. Chatterjee?
my lord, he's on his legs before.
Whenever this matter is
Praying for
called
short
on,
passport, my
it
lord.
is found by this court that he is on his legs.
No, my lord. Can you pass?
Last occasion also time was taken.
Short passport, my lord.
Petitioner was present. Other respondent number 4 was present.
My lord, short passport, my lord.
Issue. At the time of call, accommodation has been prayed for on behalf of the petitioner. And Birbhum District Central Cooperative Bank Limited. Stop. However, respondent number 4 is represented by learned advocate. Stop. Next paragraph. Acceding to the joint prayer made on behalf of the petitioner and the bank authority, hearing of this writ petitions stand adjourned till Wednesday next, comma. 4th October 2023.
Grateful lordship.
My lord, I am sorry to trouble your lordship, my lord. Item number 3, my lord, I could not reach your lordship's court in spite of extreme effort.
Sorry, mail an application.
My lord, my learned friends are here, my lord, they are present.
Respondent number 5 and 6, my lord, I'm led by my senior, Mr. Shomit Chandlal, my lord. Shall I give his name, my lord?
Yes,
Respondent number 5 is, I'm led by my
I
senior.
have passed my order already, sorry.
My lord, will your lordship not consider item number 3?
File an application.
Item number 7,
It's an old matters are taken up. If this sort of prayer is entertained, then all matters have to be restored.
My lord, just
Next. Sunu. Your matter is item number 3. What are not today, today. Next Wednesday.
deeply obliged, my lord. I have third all copies upon my learned friends.
Simply not today. Yes, next matter. Call item number.
item number 7.
Is anybody appearing for the petitioner? Yes, it has been made not today. Item number 3. On next Wednesday, it will appear under the same heading. At the time of call, issue. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. However, respondent number 2 to 4 and the state respondent are represented by learned advocates. Stop. Next paragraph. Previously on 20th September 2023, accommodation was paid for on behalf of the petitioner and the same was granted. Thereby, matter was fixed for consideration today, 27 September 2023. Stop. Next paragraph. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Intimate opinion stands vacated. Urgent xerox certificate copy. Next.
Item number 8.
Made presentation. Lord, on the last occasion, Lord, Lordship had directed us to serve the corporation, Lord. Cooperative society, Lord. We have served, Lord.
Have you served upon North Suburban Wholesale Consumers
Yes, ma'am.
Cooperative Society Limited?
We have served, my lord.
Is anybody appearing for the Consumers Cooperative Society?
Lordship, but your lordship, they are a very necessary party because it's a matter relating to the service contract between the cooperative society and an employee, your lordship. Their bylaws and their service conditions are required to finally decide this
That-
matter, your lordship.
That he's
I
right,
may-
lord, because the bylaws, my lord, they incorporate within themselves, my lord, the rules.
This is not cooperative credit structure society entity.
It is not a cooperative credit structure entity, your lordship, and they have their own service conditions which supersedes the rules which are to be followed if there is no service condition, your lordship. The rule 106 has made it clear that subject to the other service conditions, your lordship. May I read it?
Just a minute. Acha. Yes, rule 106.
Your lordship.
Please.
The method of recruitment and condition of the service of the officers and employees of cooperative societies other than cooperative credit structure entity, which it
This
is
is
not,
not cooperative
shall.
credit structure entity.
shall.
Whether SKUS is cooperative credit structure
Your
entity.
lordship, it is PAX, your lordship, primary agriculture.
It is cooperative credit structure entity.
entity, your lordship.
Very
Shall.
shall
Subject to the terms of specific contract enforceable by law and the provisions of any other law for the time being in force be as enunciated in the appendix or to this chapter, your lordship, provided that if any particular matter is not covered in this specific contract, the matter shall be guided by the method of recruitment and conditions of service as indicated in
appendix
the,
to this chapter.
your
to this
lordship.
chapter.
So the service condition which is
But
between the
appendix to this chapter provides method.
method. But if there is a specific contract which both the parties have considered to, your lordship, or agreed to,
The terms and specific contract. So- Subject to the terms and specific contract enforceable by law.
your lordship, if both the parties, the employer and employee,
Provisions of law for the time being in force. Be as enumerated if there is no,
No
if
lordship.
they don't have any bylaws. In that event, this appendix to this chapter, 200 to this chapter will
subject to your
apply.
lordship's correction, each and every cooperative society has their own bylaws, your lordship, whether that bylaws contains the
Covers
conditions,
the
the service
discipline.
conditions,
Whether
discipline,
that bylaws covers the disciplinary issue or proceedings or not,
the
that has
method,
to be ascertained.
your lordship, that is the thing.
Right, my lord. He's right, my lord, because in the affidavit in opposition that has been served upon us, my lord, I don't know, my lord, whether it has been filed before your lordship, but it has been served upon us. If your lordship sees the affidavit in opposition.
Even
we
if
have a-
this court holds that this writ petition is maintainable,
Yes.
in view of the judgment of the division bench presided over Justice Ganendranath Rai, as you have relied upon on last occasion. In that event too, there is a difficulty unless and until this credit structure, this society
Appears.
cooperative, yes.
Lord,
This
Lord, we
wholesale
shall
consumers
serve
cooperative
again, my
society
lord.
Lordship, it
We
is
shall
not
serve again.
represented, then
My
there is
lord,
a
we shall
difficulty.
serve again, my
How
lord.
does
That-
the issue to be adjudicated?
Correct. No, I'm absolutely, my lord, because the bylaws need to be seen, lord. We do not also have access to that, my lord. Let us serve again. My lord, we wrote also, my lord, we have not been.
There
provided-
are certain matters, Mr. Rai, where considering the overall position and order can be passed.
I
But this is not
agree. I
such
bow
matter.
down to your lordship, lord. My lord, I will not
lordship,
be.
I join
will not-
issue with the judgment which has been referred, your lordship,
Your judgment of 2022 presided over by Justice
Padriwala and Justice
Justice-
Aniruddha Bose,
Justice Bose and Padriwala.
your lordship.
My lord,
That I will consider very well with
that,
regard
my
to
lord, even I have, my
One-
lord, submissions
one
on that, my lord.
more
Once it
issue-
finishes, my lord.
One more issue I would like to join, your lordship. The judgments which were passed prior to 2011 cannot be equated to the, subject to your lordship's correction with the
In
present
view of
act,
these rules,
not just with these rules, your lordship kindly sees, two sections have been incorporated in this act, which was not there in the 1983 act, which I have also brought the
2006 Act.
19.
Lord, if the cause of
Cyril, on
action,
the point of mentality, you have submitted whole hog last occasion.
no, my lord, I will distinguish the judgment also. my lord.
Let me consider their points too. Today I am not finally passing any order in
Well,
view of the absence of consumer society.
My
But yes,
This is
just a
also
minute.
for our knowledge, your lordship.
Just a minute, just a minute. Just a minute. Yes. Yes,
Section 2 of the West Bengal Cooperative Societies Act.
just.
Why this new act was incorporated and implemented, your lordship?
Yes,
It shall be the policy of the state to promote cooperative societies which are instruments of equity, social justice, and economic development in fulfillment of the directive principles of the state policy as enshrined in the Constitution of India. Subsection 2. Save as otherwise expressly provided in this act, the state shall not interfere in the management and operation of the cooperative societies and shall recognize cooperative societies as democratic institutions owned, managed, and controlled by members for their economic and social betterment, operating their business based on mutual aid and cooperative principles, your lordship. Your lordship, if your lordship has the copy of the 1983 Act, your lordship will not find the section 2 in that 1983 Act.
yes. So therefore, your contention is this: unless and until it is cooperative credit structure society.
Your lordship, this is not just my contention. My contention is that the judgments which have been passed considering the act which was there at the time 1983 prior to 2011, your lordship, this special characteristics was not given to the
Even cooperative credit structure society is not beyond the ambit of this section 2 subsection 2.
your lordship, this cooperative society,
Then what about the judgment of Justice Nijjan and Justice Sanjeev Banerjee,
your lordship,
which has been relied upon by Mr. Rai last?
that was also passed prior to 2011, your lordship. And I shall show there has been an amendment in the
No, this is
constitution,
an act of 2006.
but it was implemented in the year 2011, your lordship. Kindly seize the notification. It was with effect from 18th January 2011, your lordship.
Mr. Rai, come to the judgment which you have relied upon.
Yes.
The judgment of 2008 SCC online 787 Division Bench presided over by Justice S.S. Nijjar, as is the former Chief Justice of our court. Now, the issue was maintainability, one of the issues.
Yes.
Now, come to paragraph 2.
Paragraph, my lord.
Paragraph 2 of the said judgment. Read it for a
Yes, my lord, I am
for a
reading.
moment. Yes.
The employer is a society registered under the West Bengal Cooperative Societies Act 1983 and is engaged in the banking business. The writ
So
petitioner.
therefore, it's a bank engaged in banking business.
Yes.
Now, the writ petitioner, yes, then the writ petition, that is important. Well,
Yes.
so therefore, it is in connection with a bank
Yes.
and a society which was registered under the Act of 1983.
Yes.
So Mr. Sureka is correct that subsection, section 2, subsection 2 was not applicable so far this bank is concerned. And this Act of 2006 has been enforced with effect from 2011.
Your lordship.
So therefore, this is a judgment which is dated 23rd December 2008. Now, other matters I am also considering where in each and every matter, Mr. Sureka takes the point of maintainability. That I know. But I have found upon hearing the parties that so far this cooperative credit structure entity is concerned,
Yes.
read with judgment of St. Mary's Education Society in connection with cooperative credit structure entity, writ is maintainable. That is my view. I'm expressing my view in view of the fact, if you are aware of the legal position that we have come to do you have the rules of 20 do you have the Act of 2006?
Yes, my lord, I have.
Yes, come to section 134B.
134B.
B.
Yes.
Read 134B, subsection 1A.
My lord.
Cooperative Credit Structure Society.
Credit
Yes.
structure entity
Entity.
includes the West Bengal State Cooperative Bank, a district central cooperative bank, a primary agricultural credit cooperative society, the West Bengal State Agricultural and Rural Development Bank, a primary cooperative agricultural and rural development bank. I follow your lordship. Your lordship.
Then,
Lord, that
then
this-
come to section 134C.
C.
134C, subsection 2. Special provisions applicable to cooperative credit structure entities.
Yes.
It says 134C, then come to skip over subsection 1, straightway come to subsection 2.
Yes.
We read it.
My lord, a cooperative credit structure entity shall have autonomy in all financial and internal administrative matters, including the following areas: interest rates on deposits and loans, borrowing and
Skip over ABC, come straightway to D.
personal policy, staffing, recruitment, posting, and compensation to staff.
My reading is this: they are trying to include disciplinary issues, disciplinary matters, or matters relating to discipline of the employees of these entities on based on the connotation as used under section 134C 2D, that is personnel policy. But I am not convinced, since it has not been specifically provided under section 134C 2D. In that event, these disciplinary issues are matters relating to discipline of the employees of these entities or the officers of these entities are kept outside the purview of section 134C 2D.
Interesting.
Now, therefore, the cooperative structure, credit structure entity does not have autonomy with regard to disciplinary issues. That is the position so far cooperative credit structure entity is concerned. Now come to Rule 106 of 2011 rules. In cooperative society matters, always on behalf of the state respondents and register, it is that maintainability issue is raised. That is known to us. Come to Rule 106.
Yes, ma'am.
Method of recruitment and condition of service of the officers and employees of cooperative societies. Read it.
Lord, the method of recruitment and conditions of service of the officers and employees of cooperative societies other than cooperative credit structure entities shall, subject to the terms of specific contract enforceable by law and the provisions of any law for the time being in force, be as enunciated in the appendix to this chapter.
Provided
That if any particular matter is not covered in the specific contract, the matter shall be guided by the method of recruitment and conditions of service as indicated in the appendix to this chapter. Therefore, my lord, if they have a service contract not
So
specific,
that will
then
cover.
that will prevail
That
and
will
this will be
prevail.
excluded.
Otherwise, this appendix. Now, if you consider this appendix to chapter 5, just after this 106,
Yes,
then you will come that the disciplinary issues are covered.
yes,
Because misconduct and disciplinary action, you will get under clause 4 of this appendix.
yes, it's there.
Clause 3 is conduct and discipline, and clause 4 is misconduct and disciplinary action. Then disciplinary and appellate authorities all are there. Suspension, these
Removal from
provisions you will
service.
get. So therefore, today in your case, it is not a cooperative credit structure entity.
No.
It is
is
a
not.
cooperative society.
Yes,
If this is a cooperative society, not an entity as contemplated under section 134BA 1A, in that event, this 106 will apply, rule 106 will apply. 106 says the method of recruitment and conditions of service, that has wider, these two words have wider connotations.
correct. Lord. I
That is absent in section 134C2D. That is not there. If you again consider 134C2D, it is quite complicated, you know. Come to section 134C2D, their expressions are different. Personnel policy, staffing, recruitment, posting, and compensation to staff, excluding issue relating to discipline. Come again.
Yes, my lord. Personal policy.
134, section 134.
Yes, my lord. Section
D,
134C to D.
Yes, 134C2D.
Yes.
Personal policy, staffing, recruitment, posting, and
Posting
compensation
and
to staff.
compensation to staff.
Here,
Personal policy.
this expression is strikingly distinguishable from the expression used under Rule 104, where it says that a method of recruitment and condition of service, that includes discipline.
Yes.
Conditions of service of the officers and employees of cooperative societies other than cooperative credit structure society, which has been defined under section 134B1A, because entities shall, subject to terms of specific contract enforceable by law and the provisions of law for the timing in force, be as enumerated in appendix to this chapter. So therefore, you cannot go beyond the purview of section 106. But only thing is this, in your case, as it appears that there might be an escape route, that the disciplinary proceedings dismissal order was passed on 16 November 1998.
Before the coming into force of this act.
Prior to that,
So
Your
how
Lordship,
these rules will applicable?
this rule is not applicable. Prior to that, Your Lordship, the remedy,
1983 Act will prevail.
the remedy against whom this petitioner has come forward is a cooperative society, not a cooperative bank, Your Lordship.
Yes.
It's a cooperative bank, not either falling under the definition of 134B, nor a cooperative society kind of operating any public functions, Your Lordship. It's a cooperative society, Your Lordship. And that I am carrying an order of this division bench of this honorable court, wherein it has been stated that a cooperative society which is formed by the members for the benefit of the members.
And I have also delivered a judgment in spinning mills.
Your Lordship, for that reason, a
But
cooperative society,
I have already held that this is not maintainable.
this is not
Unless and until it is a cooperative credit structure society.
structure.
Not under the old act, not under the new.
Your Lordship, I have a judgment under the new act, Your Lordship. This is a recent judgment of 2022 delivered by the honorable division bench of this honorable court, Your Lordship. I shall place that judgment if
What has been decided therein? Now, what is the position with regard to 1983 Act? In dealing with cooperative credit structure entity vis-a-vis other cooperative society? That has to be ascertained first.
Your Lordship, in simple words, what I feel is that the flavor of state which was earlier in the minds of the people that are
Because to the section 2, subsection 2 shall not apply, because that provision was not there in 1998. Which you have 1998, because this is a disciplinary proceeding which was culminated into a final order on 16 November 1998.
Your Lordship, anything done earlier in the earlier act shall continue to be or deemed to be have been done.
It has already been done.
Your Lordship,
Damage done, punishment has been imposed. Now, then it has to be considered in the light of 1983 Act.
1983.
So enlighten me on the with regard to the position which stood in terms of 1983 Act.
1983 Act, Your Lordship, section 2 and 3 was not there. However, the nature of the cooperative society did not change. In
But what
1983,
about the position with regard to the special status given to cooperate cooperative credit structure entity?
Your Lordship, possibly that was not there in the 1983 Act, and this is not a cooperative structure entity, Your Lordship.
It's a cooperative society.
It's a এই নিচের পার্টটা লিখে নাও। লিখে নাও। Wait,
Please take it back. Otherwise, you will find it difficult to address this code.
so this provision was not there in the 1980. This is the special
So
status.
therefore, in the light of 1983 Act, what was the position?
Your Lordship, in 1980,
Forget about 134P1 because that was not there when the final order in the discipline proceeding was passed.
Your Lordship. Now, in that respect, Your Lordship, firstly, we have to see this petitioner is coming against which kind of a cooperative society, Your Lordship. If it is a cooperative society of a simple nature, Your Lordship, not doing any public policy functions, Your Lordship, it will not fall under the definition. According to me, it will not fall under the definition of state, and neither will be an instrumentality of the state. In those circumstances, can a writ of mandamus be issued against a private party regarding a dispute between the employer and
What was the position with regard to Rule 106 was also not there?
there was a rule 108, Your Lordship. 108 was there, Your
What
Lordship.
does it say?
It also enumerates the appendix as a
Read it.
108. Same language. Same. Your Lordship, and the judgment of Justice Nijjar and Justice.
But think about the position of the bank pre-2006 Act. Then there was no formation of any special, there was no special status was attached to cooperative credit structure
Entities, Your Lordship.
Now all the entities were considered as cooperative society.
Cooperative society.
So in that backdrop also, Justice Nijjar and Justice Banerjee delivered a judgment that it is maintainable.
Your Lordship,
And not only this, previously Justice Ganeन्द्rnath Ray's division bench has also held that it is maintainable.
Well,
Though those are the matters in connection with the bank, you are correct. But this bank was not enjoying a separate status in terms of 1983 Act.
Your Lordship, 1983 Act did not differentiate between a bank and a cooperative society.
Yes, that is what I am telling you.
According to
Had
me,
there been a special status enjoyed, then question would have been different. The situation was difficult. so far 1983 Act was concerned. In the backdrop of that 1983 Act also, our division bench, not only one, two division benches have held in favor of the in favor of the petitioner, while holding the writ petition is maintained.
Cooperative society, your lordship, held by the members for the members, if is running a banking business, your lordship, and because it is only regulated by a Banking Regulations Act, your lordship, this will not make it a public body or a state. As I will try to distinguish this point, because all private banks which are carrying on banking activities, though they are regulated by Banking Regulations Act, I think they may not fall under the definition of state only because they are carrying on a banking business, your lordship. I will try to bring in those judgments in order to distinguish. If I
This
get
is a separate thing. The answer the query of this court,
your lordship,
that in 1980, under the 1983 Act, no separate entity was attributed to these cooperative banks. This cooperative credit structured entity was not contemplated under 1983 Act. Now, therefore, the bank as well as other societies where there was no difference, differentiation, there was no difference. Now, in that backdrop too, the division bench has held, in two division benches have held, that writ petition is maintained.
your lordship, in one of the judgment, in the judgment of the Honorable Division Bench, what I have seen is that they have also tried to give importance to the specific contract of service as seen from para 26, your lordship. The Honorable Division Bench,
Which judgment?
the Justice Nijjas and Justice Sanjeev Banerjee's judgment. your lordship.
Yes, just a minute.
The 2008 26 take hai, 26.
Yes, which paragraph?
Your starting from para 26, your lordship. It at that point of time considered 108 as it was prevalent at that point of time. আরে জজের একটা কথা ঠিক আছে, এই কোর্স তো পুরনো একটা শুরু হয়ে গেছে, মানে শেষ হয়ে গেছে না।
Paragraph 26, yes.
Rule 108, which is now akin to Rule 106
106.
of the said rules, provided as follows: conditions of service of the employees of cooperative societies. The condition of service of employees of cooperative societies shall, subject to the terms of specific contract enforceable by law and the provisions of any land for the time being in force, be as enunciated in the appendix to this chapter. On a plain reading of such rule, it is evident that a cooperative society can contract out of the conditions of service as set out in the appendix referred to in that rule. In other words, the condition of service laid down under the appendix to chapter 6 of the said rules would apply unless a cooperative society within the meaning of the said Act of 1983 had provided a separate set of conditions of service. The obvious question that arises is whether upon a cooperative society under the said Act that is not a state or other authority within the meaning of Article 12 of the Constitution formulating conditions of service which are at variance with those found in the appendix to chapter 6 of the said rules, it could ward off a writ petition as being non-maintainable. It is necessary to notice such question as one of the arguments put forward by the writ petitioner is that so long as alternate conditions of service are not put
Into
into
place.
place, the statutory conditions of service would prevail, and breach of statutory conditions of service can be made the basis of a writ petition against a cooperative society which is not a state or other authority within the meaning of Article 12 of the Constitution. Your lordship, so they have to show that there has been a breach of a statutory condition, your lordship.
Which has been embodied in the statute itself.
In the statute itself, your
But
lordship.
if the society is having a separate rules, their own rules.
That will supersede, according to me, that will
in
have
that event, if there is a violation of their own rules, then writ petition is not made.
not maintainable, your lordship. First, they have to demonstrate that, your lordship, their conditions of
Whether while drawing the proceedings against the petitioner, whether the rules which have been embodied in the statute has been followed, or the rules which were
Their internal rules
their internal rules were followed on.
were followed.
If in the case of application of internal rules,
Writ will not be
petition is-
maintainable. If there is a statutory violation, that they have to demonstrate that there is a statutory violation of such and such rule, only then, according to me, your lordship, a writ.
even if this was the position in terms of 1983 Act,
Yeah.
that too in case of a bank.
In case of a bank, and this is a cooperative society not running a banking.
But there is no distinction in between the bank and cooperative society under 1983 Act.
But in 2006, after the application of 2006 Act, your lordship, the division bench of this honorable court has stated that a cooperative society is not a state, your lordship.
There is but that 2006 Act will not apply in this case, since the final order was passed on on completion of dispute proceedings in 1998.
But the nature of cooperative society did not change, your lordship. Rather, it was given much more autonomy after 2011, application of this 2006 Act in the year 2011, your lordship. Earlier also, the cooperative society was formed by the members. This is a cooperative society. As far what I have read from the constitution, your lordship, it's a wholesale cooperative society. These are formed among the members to get wholesale item, to get consumable items at a lower rate. This is for the members, for the benefit of the members. All come together, and whatever profits is accumulated is distributed among the members. It is not that they use it for any public purpose, your lordship. So the nature of the society did not change whether in the 1983 Act or 1940 Act or the 2006 Act.
So far, other societies are concerned.
Other societies are
It remains same. Yes, show me the judgment.
জজমেন্টের প্যারাগ্রাফটা আমাদের কি আছে প্যারাগ্রাফ বল প্যারাগ্রাফ কোথায় আছে কারণ হ্যাঁ আছে আছে আমার কাছে প্যারা 37
Just a minute. Yes,
প্যারা 37 your lordship.
Lord, only one thing, Lord, the new act will still apply. Lord, although it is against me, Lord, but since I am an officer of the court, Lord, I must be fair to the court. Lord, Lordship will kindly see, Lord, section 6 of the new act.
The repeal and savings clause.
Yes.
repeal.
Lord, it
Repeal and
says,
savings.
kindly see, Lord, the section 6 of the new act. Section 6, subsection 2. Lord, I will, my Lord, develop my argument on a completely different point, Lord, whether this applies or not. Subsection 2, my Lord. Notwithstanding such repeal, anything done or suffered or any action taken, including any rule made and transaction entered into, any notification or notice issued with prospective or retrospective effect, any order passed, any appointment or registration made, any suit or proceeding commenced, any dispute decided or referred to arbitration, any right or title accrued, or any liability or obligation or penalty incurred under the Cooperative Societies Act or Bengal Cooperative Societies Act 1940, or West Bengal Cooperative Societies Act 1973, or the West Bengal Cooperative Societies Act 1983, which is our case, my lord, shall be deemed to have been done or suffered or taken under this act, as if the provisions of this act were in force at all material times when such thing was done or suffered, or such action was taken, unless otherwise specifically provided in this act. Therefore, my lord, this act still applies. Therefore, my lord, my learned friend, my lord, need not labor, my lord, to show, my lord, that this is not a bank or this is a bank, my lord. That definition by definition, and the difference, my lord, applies to my case also. My lord, my argument before your lordship would be, my lord, on an absolutely different plank. My
Well,
lord,
I will hear it.
yes, my lord. Once, my lord, he completes, my lord, I don't think, my lord, I'll be able to do it today, my lord, because I'll develop that, my lord. Since this was also not in my mind, I just found the repeal and saving clause now.
Develop
So I
your
thought,
point.
my lord,
That's
I
why
should-
the preliminary issue is being
Yes.
considered. Before entering into the merit of the issue. Yes.
Your lordship, the
Paragraph
para 37. Reported.
Yes.
37. Regarding the point raised on behalf of the respondent cooperative society, Amarnath Malik.
Yes. Give him the reference.
Matt 506 जजमेंट का डेट 14/4/11/2023. Regarding the point raised on behalf of the respondent cooperative society of mentality of the writ petition, it can be said that the said society, accepting serving its members pursuant to the prevalent law and bylaw, has not been working for promotion and preservation of any public purpose. Admittedly, it is a society to provide for its members, and any action thereof would not influence, control, or govern the public at large. The argument advanced on behalf of the cooperative society by Mr. Mitra that the same is neither the state nor the instrumentality of the state, and that it does not render any public service, and the primary motive of its operation is only to earn returns and profits, appeared to be convincing in the light of the judgment relied on by the learned senior counsel, which have been mentioned above. Accordingly, the traits of a state could not be attracted in the case of a cooperative society respondent hearing. The agreement entered into by the appellant with the cooperative society would be a contract executed between two private entities, that is the appellant and the respondent society, the dispute relating to which shall never be amenable to resolution of this court.
Yes.
Your Lordship, in the St. Mary's judgment also, it was, though it was a part of this judgment, Your Lordship.
Yes. Yes.
In this judgment also, Your Lordship, the St. Mary's judgment was
Public
considered.
element.
The public element and the nature of lease has to be decided. What is the nature of lease for which the parties are coming before the writ jurisdiction, Your Lordship?
Nature of
Lease,
Lease.
the litigation, the issue which is
nature of
involved,
lease.
Your Lordship.
That is paragraph 69 of that judgment.
Your Lordship, the paragraph 69 of the judgment. Your Lordship, in that case, may the cooperative society be called forward to with their bylaws or the service condition, because whatever will be the point of issue to be adjudicated, Your Lordship, that will directly or indirectly will be on the point whether they have their own service contract or not, whether the bylaws provide for any other disciplinary proceedings or the method.
And this is also required in order to satisfy the test as contained in the judgment of the division bench presided by Justice Dinsdale.
Your Lordship. And whether that cooperative society by the bylaws will fall under the definition of state or not, Your Lordship. That is also to be decided.
Paragraph 26 and 27. Which
Your Lordship.
yes. Which point you are trying to
Lord,
develop?
I shall develop, Lord. My argument is not, Lord, that the cooperative society, Lord, against whom, Lord, I have a cause of action is a state. I do not say that at all. Lord, in fact, the judgments which I cited also, Lord, are on the point that the cooperative society is not a state. Even if it is not a state, Lord, there are certain, Lord, factors which, my lord, the Honorable High Court takes into consideration while deciding as to whether a writ under Article 226 can be entertained or not against those entities.
Your approach would be henceforth in view of applicability of section of the Act of 2006, whether even if it is held that it is a simple cooperative society, not
Yes.
a cooperative credit structure entity. In that event also, whether considering the issue involved in this writ petition,
Yes,
whether the writ petition is maintainable
yes,
or
my
not, upon holding that that society
is not a
either
state.
a state under Article 12 or an other authorities under Article 226 of the
226. I'm grateful to your lordship. My lord, that is the point. My lord, I shall try and demonstrate, my lord, that yes, my lord, indeed, a
But
public.
issue becomes difficult so far you are concerned.
My lord, I understand, my lord, but that is the charm, my lord, of appearing before your lordship
Yes,
and
yes.
arguing. That is the charm, my lord. We are made for that, my lord. Cases will come and go. My lord, we have to
Yes, yes.
see the law develop.
Thank you for indicating that
No, my lord,
repeal and saving clause
it's my duty, my
under
lord.
section 6.
It's my duty,
Because
my
I
lord.
was under
Since-
the
my
impression
lord,
that
even
the
I did not know it,
1988
my lord,
had
because
and that
I
was due to the temptation in order to save the interest of the petitioner. That
No.
whether in 1983 Act
my lord,
there
even
is
I
a
was of the
room
same
left
mind.
open so far
I
the
was
petition
looking
is
for the repeal and saving clause, my lord. I could not find it, my lord, because usually it is at the back. My lord, here, my lord, surprisingly, it is the second clause. Therefore, my lord, I noticed it later, my lord. And my lord, I thought it to bring it to lordship.
Your
Serve
lordship,
another
only thing I would,
because their presence would be very important.
My lord, my
Would
lord.
be very important so far the adjudication of the issue involved in this writ petition is concerned.
But in fact, it was pointed
Article-
out to me by him, my
Article
lord. That
20
is why
may be some help to
I gave
him,
it up
your
to your
lordship.
lordship.
Article 20 of the Constitution may be some help to him. That is why I did not rely upon section 6, your lordship. A penal provision cannot be given a retrospective effect, your lordship. That is why I did not rely upon section 6, your lordship.
No, my lord, there is a judgment of this honorable court. There is a judgment which says, my lord, for all purposes, my lord, this act will apply, my lord. In any case, my lord, that becomes redundant in view of the argument, my lord, which I will be making. My lord, I don't say that it is a state under Article 12 at all. My lord, because that is the crux, my lord, of the Ghazi judgment, as well as, my lord, the second judgment, my lord, where on this honorable court, my lord, division sitting in division has held, my lord, that although it is not an Article 12 authority, still.
In the judgment of the division bench which you have relied upon, that is dated 11th April 2023. There is a recent judgment.
Your lordship, yes.
Now whether St. Mary's judgment has been considered.
Your lordship, it has been considered. And your lordship, it has been pointed out in paragraph. Your lordship, paragraph 7, paragraph 10, St. Mary's, वही वाला, जो 11/4/2023, तो हमारा कुमार मंदिर सेंट मेरी वाला तो आपको दिए थे ना,
सेंट मैरी का तो नहीं था साहब, साइटेशन दिए तो कॉपी में
11/4/2023 से नाम लिखिएगा हमारे मालिक. Ajay Asia was also considered, your lordship, at para 7.
Very well. Issue. When you want to come back,
Mr.
Lord, after the vacations, Lord.
let another date be fixed before vacation in order to see whether the cooperative society is
Appearing or not.
The
represented
hearing
or
matter,
not.
that's
Otherwise,
why I was
again,
telling.
there will be a further time.
Appear.
You serve notice and come back.
Lord, we shall serve.
I am giving you fortnight time to come back and to hear you, not finally, but to hear you that what points you are developing. You have you will develop in the meantime, and to see the stand of the respondent cooperative society.
Lord, only one prayer, my Lord. In case, my Lord, I am held up, my Lord, because
Yes,
before
yes.
the vacations, my Lord,
Try-
this is a hearing
try-
matter, my Lord, it will take
Try
some
to
time.
remain present.
I'll definitely, my Lord. It's a pleasure, my Lord, always.
The writ petition has been taken up for consideration pursuant to the order dated 13th September 2023 in presence of the learned advocates representing the petitioner, state respondents and respondent number 2 and 3. Stop.
ठीक है.
Next paragraph, in spite of
है ना, वो तो research करना पड़ेगा.
service of notice upon North Suburban Wholesale Consumers Cooperative Society being respondent number 4, 5, and 6. Those respondents are conspicuously not represented today before this court. Stop. Affidavit of service filed today on behalf of the petitioner is taken on record. Stop. Next paragraph. The matter is heard to some length on the point of maintainability of this writ petition. Stop. In order to adjudicate the point of maintainability as taken by the learned advocates representing learned advocates representing state respondents and respondent numbers 2 and 3, presence of North Suburban Wholesale Consumers Cooperative Society is felt necessary. The said cooperative society is required to apprise this court whether, while initiating disciplinary proceeding against the petitioner, they have followed the bylaws, they have followed their own bylaws, or the statutory provisions have been applied. Stop. Next paragraph. In view of absence of representation on behalf of the aforesaid cooperative society, the learned advocate representing the petitioner is directed to serve another notice upon the respondent number 4, 5, and 6 within 1 week from date and file another further affidavit of service on the urgent date. Stop. However, however, it is made clear if on the urgent date respondent number 4, 5, and 6 is found to remain absent, in that event, appropriate order shall be passed ensuring representation on behalf of those respondents. Stop. Next paragraph. List the matter under the same heading for further consideration on 11th October 2020.
Lord, would it be Lordship's pleasure, my lord, to indicate that they should come with the bylaws, my lord, because
Yes, I have stated.
My-
I have already recorded.
grateful, my lord. Grateful.
Item number 9.
In this matter, I am appearing for the respondent bank, my lord. My lord, I shall take both the point of maintainability as well as on merit, my lord. My lord, as your lordship indicated on the last occasion, my lord, I shall take the point of merit first, then on maintainability. My learned friend, Mr. Surekha, in earlier matter has covered many of my arguments, which I would have argued before your lordship, my lord. I have further points to argue before your lordship. So far as
Get
maintainability,
discouraged by the submissions made in other matters, because this is the issue not covered by the issue which was involved in the previous matter.
yes,
So
my
I have
lord.
already indicated that to concentrate on the merit of the case instead of taking the point of maintenance.
Yes, my lord. First, I shall address your lordship on merit. Thereafter, if so occasioned, I shall address on maintainability, my lord.
Lord, your lordships will be pleased to find that I was placed on suspension on 13th of January 2013. Then 2 charge sheets had been issued on 17/5/2013 that my lords will be pleased to find from page 59 to 61 and 79 to 81.
You are required to indicate by preparing a list of dates. Place it. Let me have a.
But
glance on this.
I do not want.
No.
Very well.
Don't
Very
try to
well. No. I do not want to escape. I do not want to escape. I say when my lords
On
desire.
your ground, on several occasions, matter has been adjourned. Place it, please.
Yes. Now, Milad, kindly see page 59 to 60.
Don't ignore this court since this is a hearing court. Yes. Charge sheet at is
page
at
59, 59 to 61.
Only one charge
Yes. 50,
at page 62.
page 59 to 61 and 79 to 81.
Why?
Because why, your lordships may kindly consider that so far as the charge sheet of at page 59 to 61, my lord, your lordship may kindly consider that this is in respect of a loan, undated loan to Messrs. Sharoda Batik. That my lords will be pleased to find from page 62. This order of page 59 to 61, the charge sheet starts from page 62.
Where is the imputation of charges?
My lord, that 62. Now, before that, my lord, your lordship may only consider one thing, that this charge sheet was issued by the managing director. The imputation of the charge, it starts from
Page
page
109,
yes.
managing director, yes.
Now, as I told you, lordships, my lord, that there are two charge sheets. Now, two replies to the charge sheets had been given. These replies to the charge sheets is
Why two charge sheets?
two charge sheets, because one was in respect of a loan, my lord, granted to Messrs. Sharada Batik, and another loan that was in respect of one Messrs. Balaji Associate. That my lords will be pleased to find from page 79. The charge, imputation of the charge is at page 82.
It's Saroda boutique.
Boutique.
You don't go to boutique. You don't require what can be done.
I cannot make a comment. I cannot make a comment.
Yes. Don't think it's surname.
I cannot make a comment.
Yes.
Now we'll have two replies to charge sheets, then two inquiry reports. That two inquiry reports were submitted by inquiry officer on Millard 17/1/2014. That my lords will be pleased to find from page 169 to 170 and 171 to 172. The inquiry report was also, my lord, prepared by the managing director.
(169) is an inquiry report. Yes.
Yes, page 169.
Where are the findings of the inquiry officer?
Findings. My lord will be pleased to find. It starts from page 173.
173,
The
under the heading
next page.
judgment.
Yes,
The
yes,
hearing judgment.
yes.
173 to 209.
Final order is removal from service.
Dismissed from service.
Dismissed from service.
Now, after this, my lord, the managing director passed an order of dismissal from service on 25th of February 2014. That my lords will be pleased to find from page 326 to 328.
Just a minute. Let
Yes,
me
my lord,
see the decisions with reasons.
To the achievement.
And on what ground you are challenging this order of punishment of
Yes,
dismissal? from
dismissal
service?
from service. Milord, I should, Milord, before I will be placing the rules right now. Now, one thing your lordship may kindly consider, that two show cause notices were issued on 28th January 2014.
Prior to issuance of charge sheet.
No, no, prior to issuance of the order of dismissal from service.
Second show cause notice.
Second show cause. At page 230 to 231, these two show cause notices has been issued without compliance of the particular Milord rule 51 of the service rules. Now, Milord, let me come to the service rules, Milord, which I have indicated, Milord. Your lordship may now my first point before my lords is
Yes.
Milord,
So
my first,
in issuing two show cause notices, where is the infraction of the rules?
yes, kindly come to rule Milord 51. Rule 51.
Rule 51.
Rule 51
What is that?
at page 116A.
What does it say?
Milord, kindly see 116A. On receipt of the report, the authority drawing up the charge sheet shall pass such orders as he may consider fit and proper, provided if it be a case of dismissal, the matter should be referred to the board. This part of the matter, Milord, was not complied with. This is number one. Number two,
So it was not referred to board.
yes. Number two, Milord,
Yes.
number two is, Milord, the petitioner, he was a manager and was discharging the role of managing director.
Petitioner.
Now, Milord,
Petitioner was the manager.
manager and was also discharging the role of the managing director. Now, kindly come to rule 48.
Yes.
The chairman is the competent authority to draw proceeding against managing director and manager.
Just a minute.
Yes, Milord, I'm sorry.
The chairman is the competent authority.
Yes,
Here, proceeding has not been drawn up by the
the
chairman.
chairman. Now,
Rule 48, you are.
yes, I am referring to rule 48 and rule 51.
Yes.
Now, my lord, your lordship may kindly consider, this is a very significant feature of the matter, that, my lord, a particular special officer sumoto formed an administrative committee, and the special officer had not been conferred with the particular, my lord, statutory jurisdiction to form an administrative committee in terms of section 36. I'm just handing over the book to my lord.
36 of
the West Bengal Cooperative Society, sir.
Act 2006 is I have book.
Yes, yes, I'm sorry.
In cooperative society matters, without books, we cannot, you cannot
Move an inch.
inch. You are relying upon section 36.
36.
May, Mr. Bhattacharya,
Yes, my
let
lord.
us stop here today
Yes.
because I have a fixed matter from 12 noon.
I must not, that's the reason I do.
So
It will take some time. I
You-
say,
you-
then
you
my
prepare-
other,
You
yes,
prepare a list of dates.
I will
and
be, I
indicate
will
the
be, I will
points.
be, I will be, I will be.
Issue. The writ petition is taken up for consideration today in presence of the learned advocates representing the petitioner, state respondents and West Bengal State Cooperative Bank Limited. Stop. List the matter for further consideration under the same heading when you want to come in.
I leave it to my lord.
Next Wednesday,
Can you give me a good time? I say, my lord, I express my inability. After vacation, that will be better. Because there are
পার্সোনাল ডিফিকাল্টিজ আছে
তুই কবে আছে বল? তুই বল
তাহলে
আছে।
ডিসেম্বর মাসে ডিসেম্বরের
আমার
ফার্স্ট
কোনো
উইক
জায়গায় কোনো অসুবিধা
yes, yes,
আমার
Mr. Rai.
এন্ড অফ
তুই বল তো
my lord I have some personal difficulties at the end of November, my lord.
Let it be on 11th of October for the timing. Let it be on 11th of October.
It could be, your
If prepare a list of dates
I
and
will
the,
be.
and the,
I
and
will
the points of
the points which I am
crucial
taking.
points.
Sir, আমি একটা কথা
Because the November end of November he has difficulty.
I do not
Then
stand
it
it.
can be, it has to be posted in the month
December.
of December.
I say I leave it. Yes, yes. I'm grateful.
That could be, your lordship, my lord.
11th
11th
October.
I'm grateful.
Yes, I'm coming.
তোর বইগুলো আলাদা। Yes. Now, my lord, excuse my importance to remind the lordships, my lord, of the last two questions. My lord just asked Mr. Banerjee, you'll have to clarify something regarding the issue with the others. Of course, I'll try to make the clarifications. Because plea which you have taken, the 12, the judgment which has been cited, that has been overruled. To what extent, to what effect? That is a very vital aspect to be taken care of. Now, my lord, Asian leather has got two parts. The first part is this, my lord, the 12, authority, Article 265. No amount can be realized as a tax without having any authority. Now, by the judicial pronouncement, the tax that has been extended to some extent to fees. No, well, I'm not going to details of this. It doesn't require. And the second part is this, refund of money. Refund of money. Now, my lord, from paragraph 14 onwards, my lord Justice Bhattacharya sitting in a division bench, observe, since the money that has been realized without having any authority, you have to refund the money. That matter, or rather at the time of taking the decisions, my lord Justice Bhattacharya rely on that Banwarila. Now, my lord, subsequently, first 2 judges, then 3 judges, 5 judges, 7 judges, ultimately Mopatlar 9 judges. One of the biggest constitutional bench after 13. So, my lord, there, just reverse. Now, my lord can ask me this question, Mr. Banerjee. So, which is actually overruled? The return of money? So, does it mean the entire judgment will go? I said, no. I cannot say like this. But the part judgment, they ought to have clarified that Mr. Mukherjee is trying his level best, with all respect to him, to put the court in the whirlpool so that my lord cannot come out from that. The question is, my lord, first part, what is the issue? Kindly take trouble to Asian leathers, my lord. That's a Dutch. If it is not there, I can hand over another copy, my. Asian leathers.
Yes, Asian leathers.
Now, there is a bundle of cases, my lord, that was referred to one Asian leathers that was moved to the single bench. Subsequently, that was referred in view of the fact that there were so many CPs and judgments are there. The learned just thought I should not decide this, but I refer to the larger bench. My lord, starts with this 482. Have you got it, my lord?
482.
Yes. Paragraph 2. It starts with mandamus appeal. Paragraph 2. Mandamus appeals are directed against the common judgment dated November 19, 2003, passed by the learned single judge of this court, by which his lordship disposed of 9 different writ applications heard analogously by directing the Kolkata Municipal Corporation to accord sanction of the building plans to the respondents without raising any development fees and such. Let us pause there for a moment. What was happened there, my lord? The skyscraper constructed. A serious problem, my lord, regarding tenants. So, corporation have to render its service. Corporation will do some jobs. It is a very enormous job. But that money is required. Because corporation never run any business. They don't have any business. They don't have any trading or industry. So only based on the revenue the public service they are rendering. So they ask, very well, I do that. I don't mind, but you have to pay that development fees. But very cleverly, what they did, my lord, they obtained there is some mistake here, my lord. They obtained the sanction because I appeared in that case, my lord, in some cases. They obtained the sanction by depositing that money. It's very significant. They deposited the money, they obtain it. And they complete the constructions. After completion of the constructions, they move the writ applications. This is totally violation of the law. Without having any authority, that has been realized. So, my lord, in disposing that, the division bench ultimately found
Yes.
why I am saying this, my lord. At the cost of reputations, taking the revenue, I am returning, I am clearing service. So it's a fees to some extent, only tax. Tax is different, my lord, anyway. So, my lord, after taking that, I utilize the money. So how can I refund the money? That is the second part. I'm coming to that. So the first part, which has been decided by Justice BHATTACHARYYA, presiding over this bench, that well, you can't. Mainly based on Article 265. That is regarding tax. As my lord knows, my lord, the basic and fundamental difference between tax and the fees. So naturally, my lord, fees no in lieu of always. Tax deriving money from me,
Yes, yes.
accumulated there funding in Madras, and paying the money to the MLMP, my lord, the pension. Very funny thing, just sitting one represented to the pension. কে তুমি মাথা দিবি দিয়েছিল আমাদের সার্ভিস দেওয়ার, but once they're elected, eligible entitled to the pension and no pension. Anyway, in one TV program, I disclosed, poor man, he is not deprived, he is not getting his pension. He's coming to court every time. Well, this is the position, get your pension. And everyone is getting the pension. Anyway, in other words, his
Wait.
lord's
Paragraph 2.
paragraph 2, my lord,
In other
where I
words-
stop.
Yes, in other words.
In other words, his lordship was of the view that the Kolkata Municipal Corporation had no right to realize that drainage development fees, as no such right has been conferred upon the corporation by virtue of the provision of the Kolkata Municipal Corporation Act or the rules. That is the crux of this case. That is the news. That is the issue. And based on Article 265, if there is no provision, you can realize that if it is a fees. Now let's pause this for a moment. Each case has got its own characteristics. I'll just cite one judgment of Justice Harit Paswat, my lord. What is precedent? Number one, what is fact here? X inducted Y as a license or the tenant, as the case may be. So does it really require any sorts of legal sanction and to be incorporated in the act? General is there. How the property is to be utilized. Corporation can use a road. Corporation can use this and that, so many things. Corporation can also invite the persons as a licensing. For the augmentation of the revenue, they can do that. But if they realize the tax, especially the fees, especially the tax, there must be legal sanctions. So is it really a fees? It's not a question of tax. Fees? It's not fees. I am asking to pay the license charges. The term fees is used because some terms to be given. And my lord may remember on the last occasion, Mr. Mukherjee handed over one document. Now, I may say so many things. What is the reaction? What you are paying? But document is with your losses, my lord. If it is not there, copy আছে আবার খুঁজবেন কেন দিয়ে আচ্ছা খুঁজবেন কেন দিয়ে দিন না থাকে দিয়ে দি খুঁজবেন কেন
That green printed page, my lord, one page.
Is there?
Yes, yes.
Kindly see at the top, bill of storage, stock rent, and electric charges. To realize the electric charges, I must have the legal sanction and should incorporate that. He's honored. He's honored. So in this way,
The court is not considering the validity of the demand relating to electric charges. Relating to electric charges.
no, it is consolidated.
The demand which has been lodged against the petitioner towards storage charge, mutation fee, then subfloor area, excess area.
That can be done without decision consideration. I expected you 4 square feet. Now forcefully enjoying the 6 square feet. I can kick you out or I can regularize it. The liberty is always with me. For that you want to pay? So nothing to do. When the statutory body or constitutional body is there, there is some problem for the statutory body. If the law says something to be done in some manner, the creature of the law cannot deviate from that. I could have understood.
That is the point.
Yes.
So if the law is law prescribes to do certain thing in a particular manner, you cannot go beyond that.
Then what is certain?
Banerjee, how you can use multiplier under what provisions?
I what?
How you can use multiplier under what provision?
Kindly appreciate one aspect, my lord.
Where is the contemplation in the law
No.
to use multiplier?
No, kindly appreciate one aspect, my lord. Suppose interest, penalty, these are incidental and consequential. It doesn't require any sanctions. It's a desire and pleasure of the parties themselves. Parties by the mutual agreement can say.
That has been decided succinctly in Asian Leather, Shreya Mercantile, and other judgments which have been relied upon. Now the query of this court, since you have relied upon the judgment of the 9-judge bench, now how this judgment of 9 judgment has an effect so far Asian Leather is concerned.
Kindly appreciate one aspect. Like that. What is the issue?
I'm telling you, I am not convinced with regard to the judgment of the division bench that has been relied upon on the last date on your behalf.
Yes.
Or on behalf of Kolkata Municipal Corporation, that is ABL.
That's
Because the division bench has not decided anything. Since the payment has been made under special circumstances, it has been held that this will not create any precedents. But ABL, the law laid down in ABL by Justice BHATTACHARYYA, Jyotirmoy Bhattacharya, that has not been decided on merit by the Honorable Division Bench. So therefore, the query of the court is today that if the 9-bench judgment has been relied upon, in what respect it has been.
I'm coming. Question is, let us not clear this confusions, if at all, in my mind. Kindly see what we are realizing. If to realize that it requires legal sanctions or statutory sanctions, then I can understand. It is simple. An occupier he was recognized as a licensee in your. I cannot do charity. I can't do that. I say you just pay that. And since you are using the electricity charges. So this is the consolidated plan we are realizing. Does it really cover under this Absumati judgment is concerned with us? I say no. They're strictly restricted to that. Tax and fees, which virtually a tax. This is neither a tax, not a fees like that. And when you are enjoying this property, you came to me, please give me that so that I can run my business. So I never invited you. Question is this, my lord. Question is this. First, there is a deviations from the because my knowledge is that Mr. Rajesh, since your client has already accepted that, probably I will not allow you to that they are illegal occupier. I can start an allegation against them. Forget about all these things. Forget about all these things, because what do we do? That has been done. Question is this, my lord. The amount which is being realized, does it really cover the ratio of this particular judgment? No. I may be wrong, my lord. I may be wrong. No, not to induct the persons. The general power. The augmentation of fee, they can do that.
But this is also drainage development fee.
That's why sometimes fees like a tax or something tax like fees. Initially, court was very rigid because the language of the constitution of the act should prevail. And language of the judgment and language of statute is not the same thing. If something is said in the judgment which is contrary to the law and the statute, it is a nullity, it's parliamentarian. Court can clarify that or court can declare in otherwise. Am I clear to losses, my lord? So, madam, that is why the fact which was involved in the order and the cases like this has got nothing to do in my case. My case. Now, kindly see, my lord, before I proceed further, I'll proceed. I'm really interested to show one judgment which is very interesting. What is precedent? Madam President, Mr. Mukherjee, precedent in arguing. Am I correct, my lord? I got understood the first time.
Slightest departure will make it not applicable.
I've cited your losses earlier occasion, cited. You
Need not rely upon.
I'm deeply then first matching this fact of this case is quite different from the situation of the fact which is not present here. Then application of judgment.
Yes.
No, my lord, there's no question of it. This is nothing with all respect, my lord. This is nothing new.
Your crux of the issue is this, that so far the corporation is concerned, the tax and the fee cannot be equated. Equated.
Actually, my lord, equated not only that, my case is something better than that. Because it is purely license fees. That license fee is not a fees like that. You are occupying my premises. I am not rendering any service. You are occupying. That is the other amount to be realized. Division of the conclusion, other things. You are occupying my premises. I cannot do the charity. You have to pay for that. Is it not like that? Rent and license is quite different, my lord. License has got a substantive legal right. And I can access anything I can enter. Rent is got a substantive legal right. Initially, it was a view that it is heritable. It is not even heritable. Only 5 years. Why that was done? Because there is something legal right. But once the tax is realized or fees is realized in that way, I've got a substantive legal right. So today, I mean, I don't like to keep you there. I must initiate proceedings. Have I right? I can do that. Nobody can stop me. So amount which is realized, neither can be say that the tax, nor in one sense can be fees. Suppose we are not saying fees, rent, we are using our rent. Does it really come under this body? No.
So it is neither tax or nor rent.
It is rent, my lord. For that, I need not take any sanction from any other, excepting, yes, you can realize. Access, yes, you can do that. There's no one.
It is a mere fee according
Yes,
to
license fees. For using the premises.
license fee, so that cannot be
Equity to all these things.
all these things, and therefore Asian leather will not apply.
No, nothing. I am not standing for regarding Asian leather. Very punish me. Punish me. Every time we are coming, people in horses, program for the corporation. Tomorrow I may be on the other side. Why not, without having any authority that has been done? I will interfere. So it is not a case like that. That's my point. It's very unfortunate. Entire thing is confused. How is it? And why not, as Mr. Mukherjee rightly pointed out, who has inducted the person having only out of 10,000, 100 share the partner, director of the company. And as a matter of right, he is a director. How the license, is it the license heritable? Is the license heritable? No. Transferable? No. So anyway, says my lord is already observed, Mr. Banerjee, probably I will not open your mouth, I will not allow you to open your mouth because you are authority to some extent. But if you pay the money, I'll accept it. But the bank remains. These are the persons with this type of attitude. They will not pay money, they will go on with their business on the long-term money, will not pay, and you can touch me. How is it? How the corporation will run? So that's why, can we see my lord? Next paragraph, paragraph 5. In all those writ applications, with which these mandamus have been analyzed, the grievance of the writ petitioner respondent, the owner of the building was that although they had complied with the formalities required under the provision of the Corporation Act. Kind of my lord, very relevant. Sanction plan is obtained, other payment already been made. So that's why they took a plea to have the sanction and to make the construction. All formalities as per Act and the rules that have been complied with. Then why you are asking me payment like that? Do you have any sanction? Formalities required under the Corporation Act and the rules when they are under. For getting sanction plan for their building, the corporation did not sanction such building on ground that the drainage development fees are required to be paid by the writ petitioner in addition to all other fees mentioned in the aforesaid act. It doesn't tally with my case. It can be taken as a precedent. Quite different case. Whatever is needed, they are paid. Corporation realize that. Suddenly corporation realize that well, certain other obligation to be discharged by corporation. Give me that money. Of course, subsequently they paid the money and complete the constructions. After that, some of them challenge, I say some of them challenge. Then Kali come to my lord. 1, 2, 3, 4, 5, 6 line.
Question which arose. And
My lord?
question which arose.
Yes.
And which has been argued by the by Mr. Mukherjee appearing for the petitioner. Is this not that not the nomenclature of the head under which this was demanded? The question which was been raised is whether in absence of the provisions of the statute,
I'm grateful.
this demand can be made.
I'm grateful. I am also not relying on the
The
nomenclature.
crux of the issue.
I am also not on the nomenclature. I'm nature. I am also relying on the nomenclature. I say very well.
It may be drainage development fee. It may be some other fees. But whether that has been contemplated under the statute.
Of course, my lord, that's why at the cost of repetition, again I say, if I don't have any authority to induct any person as a licensee, then I've got the right. So I'll do the charity, I'll induct the persons without having any fees. It's not honor. So it's not a question of that, it's a substance nature. সোনাকে রূপা বলে দেখা সোনা সময়
The case which has been made out by the petitioner is this, that yes, no payment, they are not saying that no demand can be made, but demand has to be a reasonable and in accordance with the law.
This is the second chapter will come. Mr. Mukherjee is ready with all these things.
You are in the first chapter. I am ready.
Mr. Mukherjee is, because my lord asked me, he is ready, and I know that. I've also gone through this. My lord, this is something. কিছু না পেলে খড়কুটোটা ধরি। First, let him cross the hurdle. If he cannot cross the first hurdle, gone. Whether I can be prevented from realizing the money. His stand is this. No, you can't, because without having any sanction, as per Article 265 in the Act, you cannot realize a single fortune. How is it?
No, in the lastly, it was submitted that yes, stallage charges and other fees can be levied, but that must be in accordance with law, and there must be a contemplation which empowers the municipality to demand, corporation to demand this.
My lord, solid charges, solid removal.
Stallage, not solid.
Stallage, yes.
Stallage and mutation.
That is a fallacy, my lord. I'm really happy to learn all these things. I being the owner of the house, am I not able to induct anybody for that, any statutory sanction? For the purpose of augmentation of revenue, I can do that. Or fees, or money. But if I want to impose any tax, then the illegal sanction is needed. In that venue, I allow someone to use a license. But after the induction, if I impose certain other things which amount to a tax, their sanction is needed. There's a basic and fundamental difference. Basic and fundamental difference. Am I clear to losses, my lord? If I induct anybody, X inducted Y, yes, can be that. But after induction, if the X says, no, you have to pay this thing, that thing, other thing, you cannot do that without any sanctions.
But you have approved that induction.
Now it is gone, now it is gone, my lord.
Subject to payment. You have approved that
No,
induction.
that's why I am not disturbing your lordships. Because if it is not done, I could have argued at length. How we can claim this? What is the legal right? But my hands are tied.
Since you have approved this induction.
I am still only come and pay and stay there. He will not pay. He will enjoy. And in terms of schedule, very rightly said. Then, terms of schedule. But all I've committed when I'm asking myself. And as my lord knows by this time better than me, my lord, statute is not blind. They expected, they thought in future their Ashok Banerjee may be in trouble. Kindly take trouble to read section 131.
Now, Mr. Banerjee, on the point of this 9 judgment, do you?
I'll come to that, my lord. I'll take only 10 minutes time to distinguish that. I'll take only 10 minutes time.
Let it be distinguished and then we'll.
My lord. My lord. Kindly come to paragraph. Yes, paragraph.
The judgment.
No, I don't know. I'm being half a minute time, my lord. No.
Yes, yes.
Hey, paragraph 45. Can you go to paragraph 45? Several times I've gone to that judgment, my lord, for my own interest. Paragraph 45, my lord.
Just two.
You know,
You vote today.
Paragraph 45 of the judgment of Mofathlal.
No. Judgment of Asian leather, Asian leather. Asian leather 45.
Yes, paragraph 45.
Yes. So far the case of Asian leather private limited concern, it happens because they paid the money. That is the only construction is complete. It appears that the amount was paid on 22nd November 1999 and the writ application was filed as such. The understanding that by order dates as such, during the pendency of the writ application declared this action of the corporation otherwise. Therefore, in this case, before us, there is no scope of any argument that the claim of the Asian Leather Limited was barred by the law of limitations. As this state, it will not be out of place to mention the decision of the Supreme Court in Celtic versus Kanayala, logically marked in minor,
Yes.
where the Supreme Court in clear language said that merely because the state has not returned the money paid as sales tax by the SEC, but has spent them away in the ordinary course of the business of the state will not make any difference to the position under plain terms of the Assembly contract and the SEC will be entitled to recover. That is a second aspect.
Just a minute.
That is the whole thing.
So that is with regard to recovery.
Huh? Recovery.
How does it applicable in the present case?
Aye, that is I'm saying. It's not that, my lord.
It is on the point of recovery, this sales tax officer Banaras and Kanayalal Mukundlal Sharaf was considered.
Question is this,
So
my
since
lord.
the authority to whom this tax has been paid has already spent the money, therefore there was an attempt made on behalf of the authority to raise
Realize
the
that
claim
money.
of recovery that has been negated by this court, relying upon Kanayalal.
Because the view of the court is this. Foundation is gone because by an illegal method you has the money. My lord, I am not committing any cheat. I am not committing any fraud. I have realized the money. Now, my lord, section 70 contract, my lord, no, that is also referred. By mistake, if anything is done, what is the consequence? Question is here. So far the Kanhaiya law says, no, you'll have to refund the money. Mahapadlal overruled that. Because I have used that money for your benefit. And why should I refund the money? It is not a case of cheat or fraud.
But today, whether so far this court is concerned, whether court is considering any recovery of money.
I don't think so. For the timing, I'm not on that. Because
Not considering any
no,
recovery.
because they have not yet paid the money.
Yes.
Only certain amount.
Then what score this
The
9 bench
Question
judgment
is, since
decide upon?
they realize they cited this judgment, that's why we thought it is our duty to clarify that well judgment as a whole. It is not that part judgment, judgment as a whole, part judgment has already
But in exuberance, in a way, this judgment was placed on last occasion. I was really moved that may change the color of the entire issue.
Or whatever I submitted, it is on the basis of the judgment only, not
With
on my own.
the exuberance, it was placed before this court on last occasion, Mr. Banerjee.
ওটা তো একটু মাঝে মাঝে বলতে হয় বাকি শুনছেন আজকে আমার সঙ্গে মামলা ছিল
That may change the fate of this entire issue.
No.
I was also moved. Then it struck my mind that today, if I deliver
I just
relying
no
upon,
I'm the last, no
relying upon Mr. Banerjee,
no I'm the last person like this. Yesterday I told Mr. Mukherjee that no, we'll clarify the position. Otherwise, court trust us. There should only breach of trust. And it is not the lawyer's argument, it's a court judgment, court read. Today, my lord, kindly see, we are criticizing this judgment, not the judges. Judges also remembering they committed a mistake. So what the second part is concerned. Why? Mahapadlal, that was delivered right to Asian leaders. It's a parental, kindly see the serious consequences. Mahapadlal, 9 judges bench, where Kanhaiya concept was overruled. That was delivered long back.
even then that Kanayalal was considered.
Consider.
But in the context of recovery,
I started first part and second part.
yes,
First part and second
you are correct. Mr. Banerjee, what you are submitting.
little bit, madam, little bit, not as a
No,
whole.
absolutely correct. That so reading paragraph 45, it is apparent that Kanayalal has been relied upon. But at that point of time, division bench was not expected to rely the Kanayalal in view of Mahapadlal.
We are responsible. We never pointed out. Today, my lord, rightly said, Mr. Banerjee, I was moved. Suppose you stop there and based on your and believing you, I delivered judgment. What will be my position? Who is the people, lawyer? We are responsible. So that's why I started with this. There are two parts. Neither first part of the Asian leather, the second part that question arises, will stand in my way to realize the money. What's wrong I have committed, my lord? I don't understand. You agreed. You realize that. certain amount in compliance with the court, we paid it. Is there any statutory violations? He says without having any authority of law. But he never says the statutory violation that the statute has prevented Mr. Banerjee's client to realize the money. That is one aspect. And another aspect is the authority of law. Am I clear to losses, my lord? Statute has prevented me. No, Mr. Banerjee, you cannot realize the money. Then I'm stuck now. I'll be in trouble. But he says, since there's no legal sanction, he cannot realize. Both are completely different aspects, my lord. Does it really require any statutory sanction or anything? Because 131 is very clear, 430 is very clear. Then in all cases, there must be practical. Law doesn't mean to be a theoretical abstraction. It is an instrument to do the justice to all parties. Corporation also party people losses, my lord. He needs justice. Corporation do not have any personal interest. Whatever he is doing for the service of the citizens. Of course, today I'm appearing with the corporation. When I'll appear the next day, I'll argue different to it. Anyway, so this is the positions, my lord. So that's why Mr. Mukherjee, naturally, my lord, is also the how is it? The case which has been overlooked was the second part. He ought to have clarified that, my lord, that it has got two parts. What today I have done. First part, your answer is very clear. No, I have not committed any wrong. Second part, redundant. Because no question of refund of money arises here. So that has been overlooked. So that is why what I'm.
So your first part is this, that a drainage charge should not be equated.
Absolutely correct.
And the second part is that this overruled judgment has been relied
Yes.
upon, maybe on a different context,
Yes.
but that should not be relied upon by the.
Yes.
by the-
Judgment should not be relied on. And even if it is relied, court, it is a duty of a lawyer to clarify.
Even then, paragraph 45 has no impact on the issue which this
Which is pending here. So that's why he
case
could have
recovery.
clarified that, well, my lord, I am relying on the first part of the initial letter. Today I have clarified, my lord. We said it is overlooked. To what extent that is also clarified. So not as a whole. And so for the first part is concerned, ABL others argument is there.
So even if this Mofatlal judgment, this Kanayalal judgment would not have been referred to in paragraph 45, in that even also according to you that this judgment has no application so far this
Absolutely
case is
correct.
concerned, since it's
It all depends, my lord. That's why I strongly rely on the Arjit Pasar judgment. Each word is sometimes very similar. Doesn't matter. Is that view of George Denning? Well, I'm just very much tempted. If judgment is there,
very,
I'm
very
just
reliable.
yes. I'm very much tempted.
Since
Because
I have allowed Mr. Mukherjee to argue whole hog, I will not resist it.
my lord never do that. My lord never do that. Question is, my lord.
Yes.
Of course, see, previously all those judgments were, hey, এখানে judgment কোথায় গেল? এই দিন না অরিজিৎ পাসের judgment কোথায় গেল? কোথায় আছে? তোকে বলবো কেন? তুই ওদের বলছি আমার ক্লার্কদের। ওটা কিছুই খেয়াল রাখে না। ওটা জানিয়ে চটকি। এখানে নেই। উদরপিন্ডি ভূতের গাড়ি এখানে ওখানে কোথায় ঢুকিয়ে দিয়েছে। সকালে যে কটা মামলা করেছি তার মধ্যে কোথাও ঢুকিয়ে দিয়েছে। ওটা নয় ছেড়ে দেবো হবে না judgment. Well, I'll just cycle it. Of course, in other when I argued some other case, I just handed out to Lordship's judgment, my lord. Because I really like this judgment. I like two judgments for obvious reasons. One is judgment of Justice Madden, sitting with Justice because I appeared in all of Chandrachud. I appeared in all people, all those judges, my lord. And there's a power of the High Court, my lord. Very nicely dealt with by Justice Madden. Very nicely. What is actually the power of your lordships? And it is submitted, it is observed. It's a much more wider than the Supreme Court power on that. It's very significant, my lord. I like also like this judgment because here, President very nicely, in a short judgment, only paragraph 14, 15, 16. Very nicely explained, relying on the judgment of Lord Denning. What is actually precedent? What is to be followed? What is not to be followed? That is very vital. So what I'm on, my lord, I'm just sent for this judgment. So this judgment, according to me, must be considered in the light of this particular fact. Here, what is the fact? I had the cost of justified. Now, question is this, my lord. Can I realize the interest? Yes, I can do this. Incidental consequential. Penalty, yes. You have defrauded. If I may probably use this strong word, you have defrauded me by not paying the money. I gave you the time. You didn't care. Why should I suffer? So that's why I impose the penalty. For that, my lord, had it been a case, my lord, simple penalty, the non-compliance of something consequential part, isn't it? Nowhere in the statute there is any negative imposition of it. You cannot realize any penalty. You cannot realize the interest. Purposely and consciously, lawmaker observe that. Because without having any authority, you can. What is my authority then? 131 very clear. 430 is very clear.
Yes, let us come to 430.
Yes, 131 first, my lord. 430 best.
In order to understand the meaning of statute, see, by taking advantage of presence of senior advocate like Mr. Banerjee.
My lord, kindly do not put me down. I'm not at a police. আমি কিছুই জানি না বিপুলার পৃথিবী রবীন্দ্রনাথ পড়েছে কতটুকু জানি আমি বলছি আমি কিছুই জানি না 427 ফার্স্ট can go to 427 first.
Yes, let us come to 430.
No, 430 kindly go to 427 first, my lord. Sorry to interrupt. Have you got in
427.
427. No person shall, without the general or special permission, in writing of the municipal commissioner, sale or expose for sale of any animal or article to the municipal market. Any person contravening the provision of certain any animal, so it doesn't say that.
It relates to slaughterhouse. It relates to slaughterhouse.
Private market.
It's not a relevant provision, Mr. Mohan.
426.
Because it says that the provisions of municipal markets and slaughterhouse.
Municipal market. Can you come to 426?
26 years.
Provision of municipal markets and slaughterhouses. The municipal commissioner, when authorized by the council in India, may provide and maintain the market, slaughterhouses and slaughter inside farmer, anything, stalls, shops, sales,
Pens.
pens and other buildings and such. Any municipal slaughterhouse, municipal market, found, slaughter, such other. The dominant is a type of eminent dominant. I have a right to do all these things. I have done. Does it become a special sanction? I am not prevented. No negative. You can do this thing and that thing.
Yes, you have a right to close.
Yes.
Who defies it? Who defies it, Mr. Banerjee? Nobody is saying anything contrary to that. You have a
Actually,
right.
doing that, I cannot get got the object in names and from your lordship, my lord, not by your lordship, but the court. I am prevented.
No. In general parlance, I am telling that you have a right.
That's true.
Considering the facts of the case, court have found it proper to restrain the hands of the corporation. As a result, no coercive steps could be taken. Yes.
So, I'm going to put 30. Finally, see 430. That is significant. Levy of storage, rent and fees. Can you mark it minus? Each and all words, comma, separate. Storage, rent and fees. The municipal commission may charge such storage, rent and fees as may from time to time decreased by the corporation in India. But the acquisition of these stock, shops, stand, sale or pay to the municipal market or municipal surroundings. But the right is for serving.
These are not relevant.
Madam?
These are not relevant excepting 430A1.
Yes, I'm coming.
430A1 says that charge such stallage, rent and fees as may from time to time be fixed by the corporation in this behalf for the corporation or for the occupation or use of stall, shop, set, stand, shed or pen in a municipal market or municipal slaughterhouse.
So right flows from that.
Yes, but
Don't you say-
where is the provision? Where is the provisions empowering the corporation to use multiplier? To use multiplier?
Multiplier.
Yes.
On the consequence of professional multiplier, once it is the basic thing. Suppose my lord, enhancement of rent. Initially, A and B, they interpret rent fixed. It can be enhanced subsequently. Does it require further sanction anything? If there is no right to induct, realize the rent, then question of enhancement cannot arise. But when the right is given to realize that, merely because now it is enhanced, they can jump on the 100 pay.
No, right is given to realize.
Yes,
Does it imply the right to use multiplier?
on the subject of sanction, I think can be forgotten.
Where is the provisions of the
But just because
provision in the substantive statute?
cannot provision for that. Because if my right is given to realize, that amounts to multiply that. Because the wisdom of the authority, if I don't have any right to realize, stop. And I get possible, I may be wrong. Suppose today on the internet.
Mr. Banerjee, let us come to the order under challenge.
Yes, before that, why not carry one?
The demand notice. No, that is the crux of the issue. Come to, I will hear you. Whatever you want to submit, I need to make myself also clear.
Before that,
By taking,
the judgment, so that, hey, is my interest, my God. ওরা সব জানে যাদেরকে বসে আছে না সব
জানি না, কিছুই জানি না, শিক্ষিত।
আমরা কারাকা 14 কালিস
Just a minute. ও বলেন কত টাকাতে 2008 কি আছে একটু বলতে
আই দেখ এই তো সব জানে
এটা একটু বলেন মনে নেই সত্যি মনে নেই Which paragraph you are relying upon?
14 15
14 and 15. Yes.
and 16 also. Very short judgment. Otherwise, about it minor.
Yes, 14, 15 and 16.
Substantial flexibility. One additional or different facts may make a world of difference between the conclusion in two cases. Disposal of cases by blindly pressing plans or a decision is the proper. The following words, not telling, in the matter of applying this name have become locus classica. Each case depends on its own facts and a close similarity, and mark it mind, a close similarity between one case and another. It's not enough because even a single significant features may alter the entire aspect. In deciding such cases, one should avoid the temptation to decide cases and say to the contrary by matching the color of one case against the color of another. To decide therefore on which side the line a case falls, broad resemblance the other case is not at all. This is the broad and precedent should be followed only so far as it makes it path of justice. And here to get justice, but you must cut the root and trim of the side branches so that else you will find yourself lost in the branches. My plea is to keep the path of justice clear of obstructions. So my lord, that will vital as general propositions. Yes, I think some judgment I said because of nothing with my case. My fact, my case is quite different. The law cannot stand in the foundation of our fact.
Then paragraph 16, Mr. Banerjee.
Yes, I can see that. I think-
As noted above, the accepted concept of an industry cannot be applied to law department of the government. So what was the context?
So what is-
Mr. Banerjee?
As noted above, the accepted concept of an industry cannot be applied to the law department of government. Takes it
So
up.
if I compare the CAB, Cricket Association of Bengal, with Kolkata Municipal Corporation, then we have a case. Relying upon this.
No,
judgment.
no. We defer
But
to the-
today, otherwise no judgment can be relied upon by this court.
Highly
You are
appreciate-
making the court very skeptic.
It's not my case, it's not my observations. I'm not saying anything. That part, why not, that's the observation of the court. That part, we defer to this case. Paragraph 16 refers to this fact of this case, which is before the Supreme Court. But ultimately, the law which is laid down by the Supreme Court in general.
So why your concept of application of previous precedents will not apply in the present case which this court is considering in the light of the observations and the decision taken by the Supreme Court in paragraph 14, 15 and 16?
14, 15.
Because if there is a slightest departure,
Yes,
now it is this issue has been decided and law has been settled in the context of the fact that the accepted concept of industry cannot be applied to the law department of the government.
I appreciate one aspect. That part is different to that particular case. But in general law, I say that the case which is cited by Mr. Mukherjee as a precedent, it doesn't apply because my fact is quite different. 16 is not much relevant for the timing for these reasons. And I'm not hearing for these reasons.
So you cannot invite this court to rely upon paragraph 14 and 15
Only
sans paragraph 16.
because that is in particular case. In this case, kindly appreciate, is there any laches negligence on my part? No. Is there?
Here it is very difficult to draw a fine line in between fees and tax.
Kindly appreciate one aspect, my God. Then I have to ask, but take 1 second. What should you say?
No, you need not.
What tax?
I have noted your submission.
Here, my lord, it's neither a tax nor a fee as such. Because here, what I'm hearing, what is that? Can it be compared with the general development fees? I'm just asking myself. If it is so, then what will apply? What was the fact there? What is the fact here? There, they made an application for sanctioning the plan. Authority says, pay me. Other charges, all charges are paid.
Mr. Banerjee, come to section 573. Come to section 573. 73 of your act.
The section.
Yes.
Yes.
Okay.
Why not this has been taken care of by Justice Supreme and repeated plan?
Let us read together.
Yes.
Save as otherwise provided.
Otherwise, provided in the act of the root of the argument of any sum due to the corporation on account of any charge.
Any charge, cost, expense, fees, rate or rent or any other account under this act or the rules or the regulations made thereunder shall be recoverable from the person from whom such is due as if it were a property tax.
Why not? Carry by no, that we can also watch a model case. I had a privilege to argue for them, and then they put that side of the list.
So therefore, in view of such provisions under section 573, still you can argue on the point that this rent fees charges would not be equated with tax.
Because that has been clarified by the lordship court. I just have one yes. Yes. Yes.
Lord, this is,
Kindly
Lord, this 573 concept. Was in this judgment of Nepal Chandra Kaur versus Kolkata Municipal Corporation, reported in 2003, 1 CHN, page
Yes, yes.
380. Lord, may I please,
Yes,
petitioners, the allotee,
just a minute.
sorry, ma'am, I'm sorry. 2003, 1 CHN, page 380.
জানি না ওইটা বললেন না এই কি রেখে কি হবে আমি ভুলে গেছি তো সেই জন্য প্যারাগ্রাফ
Lord, I'm placing it. Your Lordship would see.
yes
Petitioners, the allottees of a stall at Hog Market were served with a notice asking them to pay the arrears of stallage payable from the year 1990, as detailed in Annexure P10 to the present writ petition. Regulations made under this Act, the municipal commissioner may require such tenant or agent to remove himself from such market or slaughterhouse within such time as may be mentioned in the requisition. And if such tenant or agent fails to comply with such requisition, he may, in addition to any penalty which may be imposed on him under this Act, be summarily removed from such premises by the owner of the lessee thereof, or by the servant of such owner or lessee. If it appears to the municipal commissioner that in any such case, the owner of the lessee is acting in collusion with a tenant or an agent convicted as aforesaid, who fails to comply with any requisition under subsection 2, the municipal commissioner may, if he thinks fit, cancel license. Plus, these are the provisions of that. 573. Save as otherwise provided in this Act, or the rules or the regulations made thereunder, any sum due to the corporation on account of any charge, cost, expense, fee, debt, or rent, or on any other account under this Act, or the rules or the regulations made thereunder, shall be recoverable from the person from whom such sum is due as if it were a consolidated rent, provided that no proceeding of this recovery of any such sum under the section shall be commenced after a lapse of 3 years from the date on which such sum becomes due. After hearing the learned counsel of the party, and after going through the provisions contained in section 573 of the Act, I am of the view that the aforesaid section applies only to the cases of recovery of amount of any charge, cost, expense, fee, rent, or any other account for which no mode of recovery is provided for in the Act. This is very important. And in such cases, such amount should be recoverable as if it were a consolidated rate, provided, of course, that no proceedings for recovery of such sum by taking aid of section 573 should be commenced after a lapse of 3 years from the date on which such sum becomes due. In the case before us, the amount is payable as arrears of stallage, as pointed out above. Section 432 of the Act vests the municipal commissioner with the authority to take any of the steps mentioned therein in case of default in payment of stallage as provided in subsection 1C thereof. Therefore, this is not a case where there is no provision in the act or the rules or the regulation for taking steps
Against a defaulter.
and as such, the provision of section 573 cannot stand in the way of invoking the provisions contained in 432 of the Act. Thus, the corporation is not only entitled to disconnect the electric supply of the petitioner, but also to close the shop or determine the tenure of the petitioner in the stall for non-payment of the entire due. Mr. Basu in this connection placing reliance upon an unreported judgment of Kabir J, dated February 6, 1995, in the case of Ghulam Samdani versus Kolkata Municipal Corporation in matter number so and so. Mr. Basu particularly relied upon the following observation.
So it
of
is in
the-
connection with the recovery of area
Recovery.
tax, area amount.
Malad, this 430 to 420 are ultimately 427, read with 430, then 432. So whether in case of demand of stallage, areas of stallage and all that, whatever they demand, whether 573 can be put into service.
No,
430
answer is certainly no.
No.
But your act has contemplated that these are the heads which can be considered as a tax, property tax while recovering. While recovering.
Why recovered? But this is not a tax. As I have Malad on the very first outset, I submitted by submitting that one-page document that what they are paying. Are they paying any tax? Malad, very clear. What they are paying is stallage/rent and electric charges every month. And I have also stated that on records it is 3,000 some square feet, but they are actually enjoying 5,400. This extra area, what they are enjoying, for that till date, no bill has been raised, neither they are paying. And I have also shown your lordship the reverse of the bill, which are very important. Malad, this partakes the form of a contract between the stallholder and the KMC on the other part. And there is violation. What are the violations? I have indicated 1, 3, 4, and 11 specifically. Then other points are there, but I have specifically indicated there is a violation of condition 1, 3, 4, and 11. So what they are paying is rent for their occupancy and user of the space in question. It cannot be equated with a tax or a fee. In that sense, the way it is used in the statute as a tax.
Very well, let us stop here.
Regarding the limitations, I remember one judgment that was other of home capacity. No, since it is a child part, even you will be the one. That will refer to the larger. Even judge says no, the obligation can be. Some of the they differ.
The matter, the writ petition is heard in presence of the learned advocates representing the petitioners and the Kolkata Municipal Corporation. Mr. Ashok Kumar Banerjee, learned senior. Hearing is not. Next paragraph. This the matter under the matter on fifth on 5th October 2022 as 5th October, 5th Thursday. Finish it off in this side of this vacation. Yes. Yeah.
অপারেশন করতে গিয়ে পয়সা পাবে বলে জল অসুবিধা স্বাভাবিকভাবে কষ্ট করে করে কি করবো না প্রত্যেকে পাবে না দিলে করছি
What is the private respondent? Very well, please. And who is for the corporation? You are for the corporation. I cannot see, I cannot find you in view of computer screen. You are totally covered by computer screen. Where is Mr. Bhattacharya? He has not come. Use microphone, Mr. Switch on the microphone. Mr. Banerjee.
Yes. Lord, I am not in difficulty, but in installment argument, that then he will come and then he will submit. In this way, my Lord, it cannot be done, cannot run in this way. Practically, in part hearing will be met, that can be done in his absence. Because junior lawyer is here. He can take note of it.
Yes.
But question is in the midst way, my Lord, if your Lordship takes a view, if your Lordship wants to answer any query to the learned counsel for the respondent, he will not be available. We could not be able to answer. That will be the difficulty in all cases.
You recapitulate and place the facts. Let me
Yes,
hear you.
may I recapitulate? Lord, before
you said there is once in a week. That's why.
yes, that is right. Lord, the point in this case is, my Lord, my plan was sanctioned. It was under South Suburban Municipality. Now, Lord, South Suburban Municipality, my plan was sanctioned because I submitted a plan before the municipal authority for raising construction on the property. Now, Lord, who am I? Lord, my case is that I was a non-agricultural tenant because my lessee, permanent lessee, was a non-agricultural tenant. Under lessee is also non-agricultural tenant. Now, in terms of section.
Now, Mr. Banerjee, in the while considering the plan, whether your plan was sanctioned and you constructed on the basis of a sanctioned plan or not, whether your construction is authorized or unauthorized. How you last occasion also harped on this, how agricultural tenancy and the lease and the non-agricultural tenancy is germane.
Not agricultural tenant?
Tenancy is germane. Relevant.
Relevant, my Lord, because the
Sorry.
document, Lord, document.
My microphone was also
Lord, document is admitted. Lease is admitted by them, both of them. The respondent admitted the lease. The statutory respondent admitted the lease. Now, a statutory tenant, Lord, the statutory respondent admitted.
Just a minute.
Now, Lord, a statutory respondent admitted my tenancy. Now, question would be, my Lord, only the interpretation, whether, because on the basis of admitted document, I can satisfy your Lordship that under tenant is also a non-agricultural tenant. Lord, only this point I am.
Under tenant is also a non-agricultural tenant. how that is relevant in the
Because, my lord, yes,
consideration
right,
of construction being made by the petitioner.
it is relevant,
Based on whether authorized or not.
right.
Whether authorized or not.
Now, my lord, in this case, my lord, the question was that a tenant cannot make, submit a plan.
Yes.
Tenant cannot submit a plan.
That
Plan was-
judgment has been taken by the corporation while taking decision against you.
While taking decision against me.
Show me that portion.
Now, my lord, only before that, my lord,
I can find out that your this contention is relevant.
yes,
Show me that portion of this order where it has been stated that such plan cannot the plan cannot be applied for by the petitioner. I
Lord-
think the order of the corporation is at page 65.
page 65, my lord.
Yes.
Order of the corporation is at page 65.
In the context of the findings made by the corporation against you, special officer building, how your this part of your submission is relevant, that I want to know from you.
Yes, that is why, my lord, I am placing before your lordship.
Yes. Show me.
Lord, page 67, lordship kindly come to. Carefully and anxiously consider the submissions.
Just a minute. Yes, page 67, carefully. Huh?
Carefully and anxiously consider the submissions of all sides and peruse carefully the materials on record. Date of the sanction of the BS plan is on 2/1/84, when soon the new CMC Act 1980 came into force. It came into force on 4/1/84. So the application of the complainant saying revocation of the impugned BS plan will be guided under the provisions of 397 CPC. Said provision speaks that sanction or provisional sanction accorded under misrepresentation is liable to be revoked. So question whether sanction was obtained by misrepresentation or fraud by Nirod Chandra Majumdar. There is nothing before me that Sadhu Khan, who executed the Bharatiya agreement, had any ownership. Lord, they are proceeding with this. Sadhu Khan, who executed Bharatiya agreement, had any ownership. The municipal authorities
Sadhu
cannot.
Khans were the persons who made an
Sadhu Khan, because we are the tenant under Sadhu Khan. Nirod Bihari Majumdar.
Niraj Chandra Majumdar.
Majumdar, my lord, is a tenant, lord, with the same terms and conditions to raise building for the purpose of go down and factory purposes and to enjoy the property. Now, lord, lease for unlimited period, permanent lease, with heritable right of Sadhu Khan. Now, lease was in respect of a lord non-agricultural land. Once a
Whether
lease,
such kind of lease can be sanctioned.
yes, that is, lord, that is a very vital question, my lord, which I can answer, but I may not go deeper, my lord, to that, because one technical point is there on that ground itself, my lord. The impugned order is liable to be set aside. I shall come back later on. Only I am placing the facts of the case.
Yes.
Now, lord, he is a tenant. Now, lord, under section 3, capital A,
Niraj Chandra Majumdar was a tenant.
was a tenant under Sadhu Khan.
Under Sadhu Khan.
Whether now Sadhu Khan was authorized to make permanent construction on the land. Sadhu Khan in turn, Lord, gave and subletting was also authorized.
Yes, Sadhu Khan.
Subletting was also authorized. That was given. Registered lease, bilateral registered lease, unlimited period, admitted it.
In favor of Niraj Chandra Majumdar.
No, in favor of my lord Sadhu Khan by the private respondent. Now, when private respondent filed a writ petition, my lord, before this honorable court, that lease deed was annexed to the writ petition. That writ petition we have annexed in this writ petition by saying that they are admitting the title of Sadhu Khan. Title means title as a lessee to the property. as a Sadhu Khan. Therefore, the lease is admitted. My tenancy is also admitted, both of them.
Now, who applied for sanction?
I have applied, my client, that is Niroj Bihari Majumdar,
Niroj Chandra
who is a tenant, applied for sanction plan.
Now, Mr.
Mentioning that,
Mr.
not mentioning that I am a tenant. I am under a lessee, Niroj Bihari, under a lessee, Sadhu Khan.
Sadhu.
That I have mentioned
But
in the application.
whether a sublessee can may apply
Ordinarily, my lord,
can apply for sanction of grant of sanction plan before the municipal authorities.
yes, my lord,
Body,
right, my lord,
before the municipal bodies declaring him the declaring himself as tenant.
Lord, my respectful submission would be that Justice G.N. Ray's judgment, I have brought it, their person definition, my lord, that need not be the owner of the property. Justice G.N. Ray's judgment. I shall place that judgment before your lordship, whether he is entitled to or not.
The private respondent is the owner of the property.
Owner of the property, now his right is vested with effect from 1980, 1/9/1980, 9/4/1980.
According to you, Sadhu Khans are the lessee.
Sadhu Khan is the lessee, permanent lessee, with the authority to raise Pakka building, raise structures on it. Now that authority,
And petitioner is sublessee.
blood petitioner is the under tenant, under blood non-agricultural tenant. Not blood strictly, it cannot be said to be a subtenant, but under tenant, under non-agricultural tenant. Sublessee concept, my lord, in Transfer of Property Act, West Bengal Premises Tenancy Act. But under the Non-Agricultural Tenancy Act, concept is under tenant, under non-agricultural tenant.
Yes.
Now, already your lordship, then kindly come to paragraph 12. Paragraph 12
And plan was applied for by the petitioner.
by the petitioner as a tenant. Lord, not as owner of the property. But Sadhu Khan's name as owner of the property, they say he is not, he cannot be the owner. He is a lessee.
Who is according to you under tenant? Yes.
Lord, according to me, under Sadhu Khan, I am a under tenant.
Agriculture under tenant.
Under tenant, under Sadhu Khan, non-agricultural tenant. Now, Lord, in terms of section 3A, WBPT, WL, Lord, in terms of section, first of all, my Lord, whether on the basis of the documents, I have annexed the documents, whether on the basis of the documents, Lord, namely the tenancy agreement and the lease agreement, Lord, if it is a disputed, then Reed Court cannot go into that question. Disputed issue. If the documents are admitted by the parties, then effect of that document on the anvil of law would be a non-agricultural tenant that can be decided by the Reed Court. Am I clear to your lordship? That can be decided by the Reed Court. Now, my lord, your lordship, our case was that under section 3A, under tenant interest is also vested and they are elevated to under 3A of the West Bengal Land Reforms Act. Under section 3A.
Yes. Show me.
Lord, your lordship, kindly look to a boy Land Reforms Act.
এখানে land reform পাবেন।
3A, my lord. Tenants are under non-agricultural land non-agriculture tenant and other tenants vested under section 3 capital A.
So you are chiefly relying upon section 3A1.
Yes. And my lord,
Whereby there is a provision has been engrafted in order to transform the tenant under tenant into a riot
into a riot.
under the Estate
Now, my lord, with effect from the date, my lord, that has been
Estate
mentioned.
Acquisition Act 1953.
Yes, and my lord, effective date has been mentioned there. Last section, my lord, of this 3A, effective date of the enforcement
Yes,
of.
you place it according to your own reading.
Yes. Lord, now the second, no, Lord, another thing, Lord, second aspect would be a very interesting question of law. Second would be, my lord, that under section 1, because it has come to the within Calcutta Municipal Corporation.
Under section?
Under section, Lord, under the, it has been extended because South Suburban Municipality has been, Lord,
Brought under the jurisdiction of.
under
Kolkata
the
Municipal
jurisdiction of the Kolkata Municipal Corporation Act. Now, Lord, this has come after 4/1/1984 on 4/1/1984.
That South Suburban has been, has merged with
Yeah,
Kolkata.
Kolkata Municipality. Now, Lord, question would be,
What is the
Lord,
date of
second
merger?
question,
What is the date of merger?
dates of merger, my lord, on 4/1/1984.
Yes.
Lord, 4/1/1984, whereas, my lord, the provisions of this, Lord, come into force on 9th of September 1980,
Which provisions?
3A. Now, Lord, the question would be, now in terms of section 1, because this is the second question which I shall be arguing before your lordship. Second question would be that the section 1, this act means West Bengal Land Reforms Act. Section 1, this act may be called the West Bengal Land Reforms Act 1955. It extends to the whole of West Bengal except the area described in Schedule 1 of the Kolkata Municipal Corporation Act, but not excepting the area included in the said schedule, which immediately before coming into force of Kolkata Municipal Corporation Amendment Act 1983. Lord, this is under the Amendment Act. With effect from 4/1/1984, my lord, with under the Kolkata Municipal Corporation Amendment Act 1983, was comprised in the municipality of Jadavpur, South Suburban or Garden Reach. Lord, these are the three municipalities, my lord, comes within the Lord arena of the Kolkata Municipal Corporation in terms of section. Now, Lord, question would be, second question would be that my vested right, whether can be divested by extending the Calcutta Municipal Corporation. This is the second question. Because
So
if,
therefore, with
Lord,
effect
because
by virtue of merger from 4th January 1984, it is to be construed that the areas which have been amalgamated with the Kolkata Municipal Corporation.
West Bengal Land Reforms
whether
Act will
those
not
areas
apply.
Still shall remain open so far application of West Bengal Land Reforms Act 1955 would be is concerned on.
Yes, that is the question. But question would be my vested right in terms of the West Bengal Land Reforms Act under Section 3A, whether can be divested by extending the jurisdiction of the Calcutta Municipal Corporation by virtue of the Calcutta Municipal Amendment Act 1983. This is the second question. Therefore, my lord, on that ground, my contention is that I am a riot. Directly, I am entitled to construct the property. In terms of that, that is our case. Therefore, your cancellation of the plan,
Without determination of your right under section
3A. But my lord, question would be, we ought to have granted, we ought to have argued before the authority.
Then you would have made an application before the Kolkata Municipal Corporation seeking permission to construct by declaring yourself as a riot. That you have not done, Mr. Banerjee.
No, at that time, it was not declared. At the time when application was filed, Lord, at that time,
When
my
the
lord,
application for
this 3A,
seeking-
Lord, 3A did not come into force at that time. At that time, I remained a tenant under the
Then-
tenant means what?
then the relevant point is, tell me the date when you have applied for sanction plan.
Yes, when
What
I
is the date?
applied for sanction plan.
Yes. Tell me.
Now, Lord, when I applied for sanction plan, Lord, at that time, I stated that I am a tenant, under tenant, that is under tenant under the
Please tell me the
Sadhu Khan.
date, Mr. Banerjee.
Lordship.
Date of application.
Date of application. Date of application is, my lord, Lord, date of the sanction is 2/1/1984. Possibly before that, 83, maybe I don't find from my record when it was submitted. Date of sanction is 2/1/1984. Application date আছে আমার কাছে 2/1/84. Date of sanction. Date of sanction is, my lord, 2/1/84. Your lordship will get this date, Lord, from impugned order at paragraph 11.
Date of sanction.
Date of sanction. Therefore, my lord, on that day, I became a riot. Now, my lord, this argument,
But
now, my lord, what my
is
submission is,
important is that, did you urge this point while making an application seeking sanction plan?
exactly, my lord, may I draw your lordship kind attention? I ought to have urged all this point because I was not given an opportunity. They said that we have given notice. Whether we have given notice or not, that is to be decided by your lordship.
No. That is while taking decision under section 397. You are talking about taking decision under section 397.
Lordship.
But your contention is this: by virtue of section 3A of the West Bengal Land Reforms Act, your position as under tenant, non-agricultural under tenant,
Lord,
has been your status as non-agricultural under tenant has been transformed
Lord, I have
into a riot.
right.
So
Lord,
therefore, being a riot, you have every right to make an application and construct.
that,
So has it been brought to the notice of the Kolkata Municipal Corporation while seeking a sanction plan?
Lord, I have submitted the lease deed, permanent lease deed. I have submitted that I am a under tenant under Sadhu Khan.
But that will not do. You have to
The
declare
petition is to
yourself.
be given, my
You
lord.
have to declare yourself as a riot by virtue of section 3A of the West Bengal Land Reforms Act.
Lord, even if I may not declare, my lord, as a riot, because he
If you are a
but-
landlord.
but
Sir,
no, may
think
I
about the
tell you,
broader
lordship?
aspect. If you are a landlord in respect of a particular plot of land, if by declaring yourself as a tenant, if you make an application, how do you
Lord, that,
consider this?
Lord, my submission is that I am a tenant, that is under tenant under Sadhu Khan, that I have stated. Now, my lord, what would be the effect in the eye of law when he is deciding that? He is to decide that. My submission is this.
This is your application based on
He is
which
deciding my right, my lord.
the sanction was granted by the corporation.
Yes.
It is not the responsibility of the corporation to find out your actual right over the land in question. It is you are the best person to bring it to the notice of the corporation. Look here, I am the riot by operation of law in terms of section 3A of the West Bengal Land Reforms Act.
Yes, my lord.
So therefore, treating me as riot, let a plan be sanctioned in my favor.
Yes, my lord, that is the reason of which, Lord, only one
But
notice is given.
Without doing this, in effect, what you did,
Lord,
you
my,
declaring yourself as a landlord or as a
no, tenant,
by declaring yourself as a tenant,
tenant,
you apply.
to apply. Now, my lord, what would be the effect of that? I could not be able to argue. They said we appeared and argued. In the impugned order, it had been said. But I can show from their order sheet that no notice have been given, no so-called notice have been given in terms of section 397. And had this so-called notice been given to me, I ought to have gone there. I ought to have argued that I am a riot. Based on that, I am entitled to. Lord, only I am placing the facts of the case before your lordship. Now, Lord, my third point is that the order cancelling my plan.
What you have stated in your writ petition with regard to making an application before the authority,
Yes.
corporation,
Lord,
seeking
yes, Lord,
sanction
in
plan.
my application, I have stated,
Show
in
me.
my writ petition, I have stated.
Show me.
Lord,
Yes,
you kindly
in your
come
writ
to-
petition.
Yes, my lord, in my. Lord, paragraph, my lord, first of all, my lord, paragraph 7. Paragraph 7. Paragraph 6, my lord. Let us, my lord, place paragraph 6.
Yes.
That the property was situated within the jurisdiction of South Suburban Municipality and not under the respondent number 1 corporation at the material point of time. Your petitioner has filed an application under 317 of the Bengal Municipal Act 1932, along with the plan for raising construction on the property, mentioning in the application specifically that your petitioner was a tenant of the property under Bhattakharya Sadhukan. Since this is Hare Krishna Sadhukan who authorized your petitioner to make permanent construction. In the application submitted by your petitioner did not state anywhere that your petitioner was the owner of the property. In the application for proposal for sanction of the bill proposed plan, it was mentioned your petitioner is a tenant being the lawful occupier of the property, and nowhere it was mentioned that your petitioner was the owner of the property. Therefore, there was no question of any suppression of material fact or misrepresentation. If the application which was submitted by your petitioner is brought to this honorable court by directing upon the respondent number 1 corporation to produce the same, then aforesaid contention of your petitioner will support your petitioner's contention. Then your lordship kindly come to paragraph 7. That under the Bengal Municipal Act 1932, any person who intends to erect a building can make construction. Such person may lawful occupier of the property. Such lawful occupier of the property can submit a proposal for sanctioning the plan. The definition of the occupier mentioned under the Bengal Municipal Act shows that occupier means any person for the time being paying or liable to pay to the owner the rent or any portion of the rent of the land or building. Therefore, every person referred to in section 317 is referable to an occupier also. And your petitioner being an occupier was entitled to make an application for obtaining sanction of the plan, and accordingly plan was sanctioned by stating in the application that he was an occupier as a monthly tenant, and as such there was no question of any suppression of material facts. Now, my lord, next, my lord, paragraph 8. in the four corners, my lord, paragraph 8 towards the bottom. Your paragraph 8, your petitioner specifically states that in the application under section 317 of the Act or in the plan, elevation, sections and specifications submitted therewith in respect of such building, it was specifically mentioned that your petitioner was a tenant and or occupier, and nowhere it was mentioned in the four corners of the application or in the plan that your petitioner was the owner of the property. Therefore, material misrepresentation, fraudulent statement was referable in the application and or in the plan itself within the meaning of 324 of the Municipal Act. In the facts of the present case, if the respondents are called upon to produce the application submitted by your petitioner, it will be crystal clear that there was no material misrepresentation or fraudulent statement contained in the application under section 317. Now, Lord, the point would be, therefore, we have stated that. Now, Lord, what we have said in our application, second point, that the order that was, if your lordship kindly come to a straightway, my lord, this point I have taken in my writ application. Lord, order of the court was, a particular officer to deal with this case. Lordship kindly come to at page 62, my lord. Lord, initial order by Honorable
Just a
Justice
minute.
S.K. Hazari.
Just
Lord,
a minute.
though I was
Just a
not a
minute.
party, but
Just a minute, Mr. Benj. Yes, which page you are relying upon?
Lord, I am relying upon page 62, my lord.
Yes.
Page 62, because initial order, my lord, is page 38. First of all, your lordship kindly come to page 38. This is the first order. Page 38. Lord Honorable Justice Hazari, my lord, passed the order. Are the learned advocate for the petitioner, none appears for respondents. Lord, we are not the party in this writ application because we have annexed the
Private respondent filed this writ petition.
private respondent filed the writ petition without making us a party, but our lessee was made a party in the writ petition. The case of the petitioner is that petitioner is the owner of premises number so and so, was renumbered being premises number so and so. The grandfather of the petitioner, Amarendra Rai, who was absolute owner of the property, made a settlement by a deed of trust when the writ petitioner was a minor and his mother was trustee in respect of the property as long as in respect of the property
So long.
The petitioner did not attain the age of 21 years. The petitioner attained the age of 21 years in 71. The settler Amarendra Rai leased out the said property to the respondent 5 to 8 and 12 during 1951. Lord, lease is admitted. That lease was annexed to the writ petition. That is my lessee's lease, under whom I am a tenant, under tenant. 51-52, in February 1986, petitioner came to know that the respondent 5 to 8 were making arrangements for construction of multi-storied building at so and so. On further inquiry, the petitioner came to know that Calcutta Municipal Corporation had mutated the names of the respondent 5 to 8 and had got sanction of the premises under misrepresentation of facts as mentioned in the application. The further case of the petitioner is that respondents have made certain unauthorized construction and the petitioner prays for direction upon the respondents not to act in accordance with law for the purpose of cancelling the building plan and also the demolishing the unauthorized construction at premises number so and so. Considering the facts and circumstances of the case, respondent 1 to 4 and 9 are directed to draw up a proceeding by issuance of a notice of so cause upon the respondent so and so as to why sanctioned building plan should not be cancelled. And as to why the unauthorized construction, if any, made in premises number so and so should not be demolished and proceed in the matter in accordance with law and pass necessary speaking order. It is made clear that the proceedings should be initiated within 4 weeks from the date of service of the order. The complete adjudication within 6 months from the date of such initiation of the proceeding. Respondent will also consider as to whether 5 to 8 have any right to obtain such sanction plan from the Kolkata Municipal Corporation.
So that is the basis of taking decision by the corporation.
That is the basis of the taking. Now, Lord, your Lordship, kindly come to paragraph. Then this order, my Lord, was not implemented. Lord, then they file an application contempt. Thereafter, implementation of the order at page 62 is the final order.
Just a minute, just a minute. This order is at page, the order.
This order is at page, my Lord, 38.
Yes.
Now, Lord, implementation of the order of Honorable Justice S.K. Hajari was filed, writ petition. Lord, then this, Lord, page, Lord, 62. Based on this, Lord, order has been impugned, order has been passed. Page 62, 23, 3, 1999.
Yes.
The notice of the writ petition was sent under a speed post, but it appeared that the same could not be served upon the private respondent. In view of the order, I propose to make service of the notice of this writ petition upon the respondent 7 to 10 is not necessary, even though it was alleged on behalf of the writ petitioner that the notice of the writ petition was to be served upon them, but the said respondent avoided service. It appeared that pursuant to the order of this court dated 5/15/11/94 made in the matter number so and so, a proceeding was initiated on the basis of the allegation by the writ petitioner. It also appeared that order dated 7/12 passed by the Deputy Municipal Commissioner Building in the said proceeding that awaiting reports from the Deputy Commissioner Revenue outlined and the executive engineer Borough so and so said proceeding was suspended since thereafter it has been alleged in the writ petition that the same has not been concluded. Mr. Banerjee, learned advocate appearing on behalf of the Calcutta Municipal Corporation, could not substantiate upon production of any material that the same has been completed in the meantime. In these facts and circumstances, the writ petition is disposed of by directing the chief engineer, namely Sri Aurobindo Satra, Calcutta Municipal Corporation, who is presently authorized to look into the matter relating to the building, to conclude the proceeding if the same has not been concluded. In the meantime, in accordance with provisions by giving reasonable opportunity of being heard to the writ petitioner and the respondent 7 to 16, peremptorily within a period of 2 months.
Yes.
Lord, now my submission would be before your Lordship. Now, Lord, High Court directed the order, Lord, on 23/3/1999, Lord, to to Sri Aurobindo Satra, Chief Engineer,
Yes.
by name. Now, my lord, when the impugned order at page 65, my lord, was passed by whom? Passed by T.B. Dev.
What can be done? If Aurobindo Santra was not there, no.
No,
order
there,
will be
he
passed.
was there. He was there at the material, because 2 months, gap of 2 months. That is why they kindly look to the date. Date of passing impugned order, 18/6/99. (18/6/99) and 23/3/1999. And he was available in the department at all the material point of time. Lord, I have taken this point specifically in my reply as well as in the writ petition. Lord, only narration of facts I have given, Lord, in my
But today,
supplementary.
if I set aside the order, since Aurobindo Santra did not dispose of this application or did not dispose of the issue under section 397, then today Aurobindo Santra cannot hear the matter. He must have retired in the meantime.
Yes.
So then
No, therefore,
purpose would
no,
be
so the
served.
purpose will be served, my lord. We shall have to argue on that because we are a
Different thing. That on that issue, you may take a point that we are not given opportunity of making
yes, that
deliberation.
is,
before the
I have said that.
that issue can be gone into. But that said Aurobindo Santra has to hear the matter. That scope is no more left
But my
open.
lord, so far
perhaps.
that part is concerned, what would be the effect of that order? That order is illegal.
For that, you could
Judicial
have
review.
filed an contempt application before the said bench.
Lord, I have,
Aurobindo Santra did
I
not,
have, Lord, on this, my lord,
decide the issue.
Lord, I have 2 judgments on this. One is Honorable Justice DP Kundu. Another is the division bench presided over by Honorable Justice Girish Chandra Gupta. Lord, before that, my lord, I may be permitted to file supplementary. We have given, my lord, the copy. Only one line that he was available in the department. We have taken in the reply also, my lord, in the.
At this stage, I will not permit you anything to do.
Lord,
I will
no,
only
this
hear
is
you.
not a new point. Lord, that is why I want to draw your lordship kind attention.
Because I have heard this matter last
I
occasion
have
also.
taken this point in the writ petition, especially
Then based on the point which you have taken in the writ petition, you
as well
turn
as
up your case.
my lord, in the reply also. I have taken and I have served the copy to them.
Then
15
why,
days back.
since you have taken this point in the writ petition, what for you are trying to file a supplementary affidavit at this belated stage?
Narration, only narration of that gentleman was available at that time.
That is not required. It's a point of
Practically, my lord,
since there is a direction by this court, you have taken this point. That is enough. Court will consider this.
yes.
No supplementary affidavit is required.
Lord, this
If I
point we have
allow you to
taken.
file a supplementary affidavit, then I have to again allow others to file a reply. Then it will the matter will
Lord,
be
I have taken in my writ
writ
petition as
petition.
well
That
as
will
reply.
enough. That
Lord,
will
may
be
I-
enough to consider this point.
Lordship,
Whether there was any necessity to take decision by
Lordship,
said Aurobindo Satra or not.
Lordship.
Yes.
Lordship, kindly come to my lord, my writ application. Lord, we have taken this, my lord. Lord, paragraph 11 of my writ petition.
I was thinking that why last occasion also you while making submission, you also harped on this, that in terms of section 3 capital A of the West Bengal Land Reforms Act, this non-agricultural subtenance has got right. Now, if I appreciate your point that yes, non-agricultural subtenant by virtue of an application of provisions under section 3A of the West Bengal Land Reforms Act 1955 is automatically transformed into a riot, thereby accruing right accrues in favor of the riot who was previously non-agricultural subtenant to make an application for seeking permission to construct. Then what prevented the petitioner to indicate these points while making application seeking sanction?
Lord, my respectful submission that if I may not state the law, But if the interpretation of a document,
Any
because in
whisper-
terms of
any
the order,
any whisper in this application that he applied on claiming his right as non-agricultural subtenant, as non-agricultural subtenant who has
Lord,
been
practically,
transformed,
my lord,
who has been transformed into a riot, therefore having a right.
Lord, truly,
The
Lord,
relevant,
truly
relevant
speaking,
paragraphs of your writ petition, paragraphs 7, 6, 7, 8, which you have placed, that those paragraphs are silent on this.
Lord, truly speaking before your lordship, that they did not know the law. They did not know the law, they did not say this. They simply say that I am a tenant under the Sadhu Khan, and therefore and his name was recorded as an occupier, and based on that, my lord, plan was sanctioned. It is not a case of suppression. If I say something which is not correct,
No, question is.
that is
I am
called
not-
suppression.
I am not saying anything with regard to misrepresentation or suppression or fraud.
No,
But-
but your lordship is
but
saying,
your
my lord, I
right-
understood.
Your right over the property could have been considered in the context of this point which you are developing today.
Yes, now, my lord, this is a
So
legal
since this
point.
Point was not
Lord,
taken.
my
It was
respectful,
not considered.
right.
There was no scope left open to the
Lord,
concerned authority
my
of the
submit-
KMC to take this. to
yes,
consider
Lord,
this
my
issue.
submission is this is a legal point. Legal point I can argue, which goes to the root of the case. I can argue even before a Supreme Court.
Yes, that you can argue, but it's a case where court is considering the validity of the application which was made before the authority in order to get a sanction plan. Now, if it has been declared before the authority that he is a tenant having right to construct, then why it will not be construed as suppression?
No, this is not a what suppression, my lord. They spoken with the spirit of the law. Spirit of the law, I did not say. That does not mean, my lord, it is a
You have
suppression of law.
stated in your.
No, this is not a suppression of law.
In paragraphs
Lord, this is not a
7, 8
Lord,
and 9, that you are the tenant having have derived right from the landlord or the original or the lessee. You are the sublessee or subtenant, whatever you are describing in a way you are describing yourself having right to construct based on the permission which has been accorded by either by the landowner or by the lessee. Then where is the wrong committed by the Kolkata Municipal Corporation?
no, wrong committed by the
in
Kolkata
coming
Municipal
to a
Corporation.
conclusion that this is a case of suppression and fraud.
Lord, my name has been
So
recorded as an occupier.
Therefore, the point which you are taking today, that is a point of law that can be taken at any stage of the proceedings, that may not be available to you in view of the facts of this case. That because your application was assessed while granting sanction plan based on the statement which you made in your application.
Tenant,
So
I'm
had-
entitled.
had-
Lord,
It
as
would-
a
it would have been
tenant, I'm
relevant-
entitled.
It would have been a relevant consideration before this court had you, if you had urged this point of point based on section 3A of 1955 Act, that your entity or your position has been transformed into a right. So on the date when this application was made, if this application was not properly made and certain
Lord, I don't find
points
any
were-
application.
points
That
were
is why.
certain points were not urged, then on what basis, what was the wrong so far corporation is concerned? to
Lord,
come to a
corporation,
conclusion that is a case of fraud and
corporation committed a wrong by saying that it is a that he is not the owner of the property, is a tenant. Tenant cannot make any construction on the property. I am a tenant, under the non-agricultural tenant in the eye of law. Document is admitted.
non-agricultural tenant under in terms of section 3A, the right which you are entitled to derive, that issue was not taken before the corporation.
Lord, that issue was not taken by the
If it is not
corporation.
taken before the
But
corporation, it is
corporation
not
is bound to-
expected and it is not presumed that corporation would go into the issue and take a decision
Lord,
while permitting you to sanction.
Lord,
Corporation proceeded on what basis? That you were having the authority to construct which you have accrued from the sublessee.
right, my lord, so far that part is concerned, my argument is
Or
the law
according to
requires-
agricultural tenant.
law requires, my lord, law requires that whether I am a person or not, lawful occupier or not, that is the law. Law requires that. Lord, let us place the judgment of Honorable Justice G.N. Ray, where says who is entitled, owner is entitled to make construction, or any person occupying land is also entitled to make construction on the basis of a sanction plan. He interpreted the,
Is it a relevant consideration before this court today?
yes,
In
because
the
whether I have a right or
in
not,
the context of the application which you have made in before the corporation.
Lord, whether I have a right
Where
or
is the
not,
statement in
yes,
the,
I have a right on the
Banerjee,
basis of
where
that
is the
document.
statement in the writ petition?
Lord,
That you have taken this point.
Lord, may I to draw your lordship's kind attention that I am a under tenant, under Sadhu Khan. This is placed on record. Now, what would be my status in the eye of law in terms of the judgment of Justice
Corporation will
S.K.
decide.
Hajari? S.K. Hajari, my lord, is required to decide.
Unless and until you urge it, it will be decided by the corporation while taking decision
Lord, how can
whether
I
the
urge
plan
it?
is sanctioned or not.
Lord, how can I? Lord, how can?
Far-fetched,
Lord, say question
argument,
would be,
Mr. Banerjee.
Lord, question would be, how can I urge it, my lord? How can I urge
No,
it
you-
unless I am
you-
giving an opportunity to argue?
You could have stated in your application.
No, I was not given any so cause in this case. I was not given any so cause in this case.
In your own, you made an application before the authority seeking sanction plan.
Lord, we are
Plan was sanctioned
sitting
based on
over.
your application. In the application, did you take this point?
In the application, my lord, I have said that I am a tenant under Sadhu Khan. This is not suppression. I am a tenant under Sadhu Khan.
And you have,
And if
you
I
have
am
been
not
authorized
entitled,
by
my lord,
Sadhu
if I am not
Khans.
entitled,
You have authorized by Sadhu Khans to construct.
no, I was not authorized by Sadhu Khan, my lord, in the Lord tenancy agreement, it has been stated you are entitled to construct on the vacant land.
Show me the tenancy.
Accordingly, I
Show me the
constructed.
tenancy agreement.
Yes,
Where
kindly-
this has been contemplated.
yes, kindly come to the tenancy agreement, my lord. Lord, kindly come to page 27. Tenancy agreement, my lord, page 27.
Yes.
বটকৃষ্ণ সাধু খান, হরেন্দ্রনাথ সাধু খান, Lord, then Khirot Chandra Mojumdar, Osini Kumar Mojumdar.
This is Nirod Chandra Mojumdar.
Nirod Chandra, yes, Nirod Chandra Mojumdar. কসর ডাঙ্গা জমি সংক্রান্ত মাসিক ভাড়ার এগ্রিমেন্ট পত্র মিতং কার্জন থাকে জেলা 24 পরগনা বেহালা সাউথ সুবারবান মিউনিসিপ্যালিটি অন্তর্গত মৌজা বেহালা খতিয়ান নাম্বার 6 কাটা ভূমাদির মধ্যে নিম্ন ক তফসিল বর্ণিত চিহ্নিত চৌহদ্দি বিশিষ্ট কুমিবেটি 1 কাটা 12 ছটাক ভূমি দ্বিতীয় পক্ষ আপনি কারখানা অফিস গৃহাদি নির্মাণের উদ্দেশ্যে মাসিক ভাড়া সত্ত্বে বন্দোবস্ত লইবার প্রার্থনা করিলে প্রথম পক্ষ আমরা নিম্নলিখিত শর্তে আপনার প্রস্তাব সম্মত মতে
Come to
আপনাকে
straightway to clause 5. That is important.
yes clause 5
Yes.
দ্বিতীয় পক্ষ উক্ত বন্দোবস্ত নিজ খরচায় নিজ প্রয়োজন মাফিক কাঁচা পাকা গৃহাদি নির্মাণ করিতে পারিবেন তদ্নির্মিত গৃহাদি কারখানা ও অফিসের উদ্দেশ্যে যদিচ্ছা মতে ভোগ দখল করিতে থাকিবেন
Does it give you power to construct go down?
yes my lord
Yes.
লর্ড নিজ খরচায় কাঁচা গৃহাদি নির্মাণ করিতে পারিবেন I was allowed to make construction on the property
including warehouse.
ও তদ্নির্মিত গৃহাদি ও কারখানা ও কংক্রিটের যদি ইচ্ছা মতে ভোগ দখল করিতে পারিবেন।
নিজ প্রয়োজন
কারখানা
মাফিক কাঁচা পাকা গৃহাদি নির্মাণ করিতে পারবেন।
কাঁচা পাকা গৃহাদি নির্মাণ করিতে এবং তৎনির্মিত গৃহাদি কারখানা ও অফিসের উদ্দেশ্যে
ব্যবহার করতে পারবেন। Does it give you right to construct godown?
No, this is not go down. ও অফিসের উদ্দেশ্যে, অফিসের উদ্দেশ্যে, not go down. But I was allowed to make
You
construction
have
on the property.
constructed godown.
No, no. I have, well, my office and factory. Well, they have admitted.
Banerjee, your
No, no,
case is
they have
they have
admitted.
constructed godown.
No, 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 no. They have admitted, my lord.
In
Custom.
fact, my lord, in the agreement, my lord, kindly see pay paragraph 5, which has my lord reading. My lord, what has done, they have done, my lord, kindly see. 5, item number 5, দ্বিতীয় পক্ষ উক্ত ব্যবসায়ী ভূমির উপর নিম্ন খরচায় নিজের প্রয়োজন মাফিক কাঁচা পাকা গৃহাদি নির্মাণ করতে পারিবেন এবং নির্মিত গৃহাদি কারখানা অফিসের উদ্দেশ্যে ভোগ দখল করতে পারবেন। That it has been specifically stated what he permitted to work. What has happened? 2+1, 3-story building has been constructed and not for this purpose, but for residential purpose.
Residential.
No, no, no.
No,
This is
no,
wrong,
no.
my lord. They have admitted. Lord, respondent, private respondent said that for the purpose of, Lord, building, for the purpose of factory,
Yes, yes.
kindly look to the, my lord, they are affidavit, the affidavit of the respondent. Affidavit of the private respondent in this regard,
Just a minute.
the private respondent. Therefore, I have been authorized to make construction. Now, Lord, that question does not arise at all in terms of 3A. That authority was given. Lord, 76.
Yes.
Lord, if your lordship kindly come to the affidavit of the respondent, private
That
respondent.
was the basic thing based on which corporation has taken a decision against you. Because you have relied upon this tenancy agreement and clause 5. As I remember, last occasion also you argued that
Now, this
on the
question, my
basis
lord,
of this clause 5, corporation came to the to the finding that there is a case of misrepresentation. Because relying upon this clause 5, whether you were entitled to construct G+2, so far I remember, it is recorded in the order, G+2 storied residential building.
yes. Now, my lord, without any so-called notice and without any opportunity of hearing heard. That is to be seen by your lordship. I will argue that point. And my lord, what is the contention of the private respondent? That is for the purpose of, Lord, the factory. And it is still being used, office.
If no opportunity of hearing, then it has to be considered. Because section 397 also, under section 397, it is required to grant opportunity of hearing to the petitioner.
So-called is to be,
parties.
Lord, their case is that we have given opportunity, our lawyer was present. But I will show from their own document that they have issued a notice under section, so-called notice under section 400. I have given that. No so-called notice as to why my plan will not be sanctioned. Lord, one is so-called, thereafter hearing. Lord,
Now it boils down to this, that your main point is no show cause and no opportunity.
that
It
is
will
all,
be better
that is,
to take this point in order to satisfy satisfy the court. Now, very well, you reserve
a
this
better point, my lord, is
you reserve this point on the next date. That will be argued in presence of your In presence of the.
Last day also you was absent, my lord. Today also, my lord, I am the
Other
last
points,
person to
only on the
oppose.
points of show cause and opportunity of hearing I will get.
And also, my lord,
No
also,
other points.
I have, my lord, point is, yes, that the order that has been passed by this court, Lord,
West
there
Bengal
is,
Land Reforms
there
Act,
are
Section
two-
3A,
two judgments.
then tenancy agreement, all I have heard you.
No, no,
Only
I
on the
will have
point
to
of
place,
show cause and opportunity of hearing.
Lord, I will place the ruling on that. I will place a ruling on that.
The writ petition is heard in presence of the learned advocates representing the parties. Stop. Mr. Haradon Banerjee, learned counsel representing the petitioner, has made sufficient. Stop. Hearing of this matter stands adjourned till Wednesday, next Wednesday.
Lord, next Wednesday, I have difficulty, my lord. Then Wednesday, Lord, Wednesday week, my lord.
On 4th October, next Wednesday, Mr. Banerjee, on 4th October.
4th October, that is my difficulty, my lord. Then, my lord, on 10th,
on
11th of October, my lord.
কি বলছিলাম? 11th October 20. এটা এর মধ্যে থাকবে। না, সই করার পর আমার কাছে তো
মনে রাখি। Your lordship distinctly remember what I argued 15 days ago. Distinctly remember that. Good.
Well,
For the private respondents.
Well, I beg to appear on behalf of the petitioner. On the last occasion, Manor has been pleased to direct us to file an affidavit in reply against the opposition filed by them. Therefore, the first time disclosed that the property has been mortgaged before I filed this writ petition, and though they disclose
My
certain
lord has
documents,
passed an order directing us to disclose whether any third party right has
right
been
has been
created
created or not.
in respect of the premises between the period of the order of regularization and the filing of the writ petition.
So reply is ready, my lord. There is a 2-3 days delay in filing, my lord. We ready with the reply, and I am serving a copy in court today. And this is it.
KMC character copy.
My lord, I am led by Mr. Subhashish Sengupta, my lord, if one remembers. My lord, the 2 points that we have asked in this matter.
Are you praying for time or?
I am praying for time
Say
for
so
today.
straightway you ask for
I pray. I'm praying for time on the ground of Subhashish Sengupta. But if I just recollect what is the 2 points that we are actually on. That is whether we have come before this honorable court lately. And second of all, if any third party interest is created, that whether an unauthorized construction, whether it will remain or not.
issue.
Can we fix this matter? And
My lord, may we come back on 11th, my lord, subject to my
Matters
lord.
got fixed on
My lord,
11th.
next
There will
week,
be
my lord,
discussion.
some.
Yes, on 4th, what will
My
be
lord,
the
only
problem?
I've got it right now, my lord, from tomorrow to Tuesday, my lord, we're not, long weekend, my lord, we're not here. They have to take instruction from the client, my lord. So only, my lord, if, my lord,
Let
subject.
it remain in the list.
Because my lord, this
In
this
terms
has
of
quite a number of pages from what I can see. It's not a pithy one.
the thin exception. The matter is taken up for consideration today when Mr. Dotto, learned advocate representing the petitioners, has filed exception to the affidavit filed on behalf of respondent number 5 and 6.
5 and 6.
Respondent number 5 and 6, and the same is taken on record. Stop. Next paragraph. However, Mr. Dotto has prayed for accommodation, which is not seriously opposed by the learned advocate representing respondent numbers 4 and 5. Stop. Next paragraph. Hearing of this matters, hearing of this writ petition stands adjourned till Wednesday next 4th October 2020. Please, Your Lordship.
Grateful.
My lord, item number 3.
My lord, I am appearing for the petitioner in this matter.
Stay my lord, from the appellate court.
My lord, there is no stay.
My lord,
As
I
it-
will see, page number 2, I have marked it, sorry. Stay order. Yes.
Is there, my lord, the greater issue that whether a non-citizen can, my lord, proceed under the assumption of a mutuali is now being decided by Justice Shortkar, my lord. And that matter has also now been contemporaneously called,
But that issue was not before this court.
not before your lordship's court, but my lord, that issue was urged on behalf of the intervener
Just a minute.
in the appeal court. So appeal court, my lord, has passed this direction, which is in the last page.
Revisional application is fixed for hearing on 21st September 2023. And the appeal is again to be taken up on 20th September 2023. This has been recorded.
Yes. And my lord, right now the revisional application,
September 2023, that means tomorrow.
the revisional application has been called at this moment.
It has been called.
It's been taken up by Justice Shortkar, my lord.
So on 21st September 2023, it was not concluded.
It was not called on that. It was running in the list.
Issue. There are two writ petitions or
Yes,
one?
my lord,
my
there are two
lord.
writ petitions.
দুটো writ petitioner উপর যেভাবে করা ছিল both the writ petitions are taken up for consideration today when the learned advocate representing the parties have drawn attention of this court to the order dated 6th September 2023 passed by the Honorable Division Bench.
Definitely.
Stop. Next paragraph, in view of the order dated 6th September 2023. Nah, get it out. In consideration, stop. Which is taken on record, বললাম দেখো তো। Stop. The order dated 6th September 2023 is taken on record. Stop. Let both the writ petitions go out of list with liberty to mention after disposal of the appeal. After disposal of the appeals. Stop.
Yes. Deeply.
Call the appellate side matters. 96.
Item number 96 from appellate side, monthly cause list.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph lists the matter under the heading Motion Group 5 Municipality for disposal on এই position. On 5th October 2023. So however, it is made clear if on the agenda date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 97.
97, I am for the Rajarhat Gopalpur municipality.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, Rajarhat Gopalpur municipality is represented by learned advocate. Stop. Next paragraph is the matter under the heading Motion Group 5 Municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the agenda date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 98.
At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. Next paragraph, however, however, Kolkata Municipal Corporation is represented by learned advocate. Stop. Next paragraph, it appears video order dated 5th August 2014. A coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading Hearing Group 5 Municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the adjourned date petitioners go unrepresented, consequential order shall be passed. Next,
Item number 99.
at the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. Next paragraph, it appears video order dated 6th August 2014. A coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. List the matter under the heading Hearing Group 5 Municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the adjourned date petitioners go unrepresented, consequential order shall be passed. Next,
Item number 100.
which 100?
My lord, I am appearing on behalf of the Calcutta Municipal Corporation led by Mr. Biswajit Mukherjee.
Where is he?
He is engaged in code number 6, my lord.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, Kolkata Municipal Corporation is represented by learned advocate. Stop. Next paragraph. It appears video order dated 9 December 2014. Parties were directed to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. List the matter under the heading Hearing Group 5 Municipality for disposal on 5th October 2023. Stop. However, it is made clear from the adjourned date petitioner goes unrepresented, consequential order shall be passed.
101.
But I'm for the Howrah Municipal Corporation in this matter.
এখন দরকার নেই। আছে, যদি clear কিছু। At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. However, Howrah Municipal Corporation is represented by learned advocates. Stop. Next paragraph. List the matter under the heading hearing group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed.
Okay.
Next,
102,
at the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph lists the matter under the heading hearing group 5 municipality for disposal. On 5th October 2023. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed.
103,
No, so I'm for the municipal, relaxation of the municipal.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, Rajpur Sonarpur municipality is represented by learned advocate. Stop. Next paragraph, it appears video order dated 25th September 2014. A coordinate bench directed the parties to exchange affidavit. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph, list the matter under the heading hearing group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
104.
At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. Next paragraph, it appears video order dated 27th April 2015. A coordinate bench directed the parties to exchange affidavit. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph, lists the matter under the heading hearing group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed.
Hundred and five.
At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. Next paragraph, it appears video order dated 19th November 2014, a coordinate being directed the parties to exchange affidavit. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading hearing group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. Next.
Hundred and six.
I'm for the petition.
Yes.
I'm for the petition. The father of the petitioner, my lord, the employee under the, my lord, the corporation, my lord, the subsequent.
Kolkata Municipal Corporation.
Yes. The subsequently thereafter, my lord, the medical board declared the incapacity of the petitioner's father and.
Permanently incapacitated.
Yes. My lord, kindly see, my lord, the page 33, my lord.
Yes, page 33.
Yes, this is, my lord, declared by the medical board, my lord, the permanently incapacitated in the for the further service, and subsequently thereafter, my lord, the page.
Where? 15 July 1997 document. But it is struck off.
Yes, and subsequently thereafter, my lord, the page 33, my lord, the is terminated from the service due to, my lord, the on the, my lord, the view of the medical board, my lord, on the medical ground.
But what is the finding that petitioner
And
was
finding, my lord,
petitioner's father
subsequent.
was permanently incapacitated?
Yes, my lord, subsequently thereafter, my lord, the.
Where is the finding that petitioner's father was permanently incapacitated?
Well, this is the certificate annexed in page 33, my lord.
Yes, show me.
1, 2, 3, 4. In 5 lines, my lord, from the bottom, my lord.
Just a minute. Yes, then.
Yes, my lord, next is my page 33, my lord, the issued the letter of termination on the ground, on the medical ground is, my lord, the permanently incapacitated for that. My lord, this page 33, my lord. 34, my lord, sorry.
Page 34.
Yes. And subsequently thereafter, my lord, the proposal of the appointment of the petitioner's, my lord, the son, my lord, kindly page 36, my lord.
36.
Yes.
The third paragraph, my lord, the
Just a minute.
petition.
So deputy assessor, collector recommended your case.
Yes.
Then what happened?
And my lord, next page, my lord, the page 37, my lord, the checklist petitioners are applied, but submitting all documents. And my lord, page 33, my lord, be certified that the applicant applied within the prescribed time limits of the 6 months from the date of the unfit. My lord, kindly see page 38, my lord.
You filed a writ petition.
Yes, so subsequently, my lord, in action on the part of the corporation, my lord, I filed the writ petition, my page 41 onward, my lord.
Then what happened in terms of
The
this order?
subsequently thereafter passed my lord, the page 55, my lord, the impugned order. 52, my lord. it is.
Where is the wrong in this order? In view of the conditions as contained in the order dated 17 January 2009.
Only but on the ground of the
There
financial.
are two conditions which have been stipulated.
Yes.
So these two conditions fulfills in your case. Who is appearing for the corporation? Have you filed your affidavit? There is a direction for filing affidavit.
But
Yes.
But my lord,
Do you want to file any affidavit
your lordship, yes, I can
or you want to take instruction and come back?
very well do that.
Yes.
The pay, my lord, the paragraph 23, my lord, the same ground, my lord, the one has been granted appointment in the same similar circumstances.
If it is wrongly done, then why that does not confer you a right to get this same treatment? There is no concept of negative equality. You
No,
have
only, my
to
lord,
you have
the-
to build up your own case,
Yes, my lord, only
not
the,
being influenced by the treatment which has been given to some other similarly circumstanced candidates.
only one
Satisfy that these two conditions which have been stipulated, very well, let him take an instruction and file a report in the form of affidavit.
that
Issue.
lordship will kindly, my lord, subject to lordship's consider a copy of the requisition will be given to.
Have a copy.
Copy has
Old matter. Previously, Mr. N.C. Bihani and Papia Banerjee Bihani appeared.
But today I received instruction to appear in
Very
this.
good. The writ petition is taken up for consideration in
Well, I
presence
handed
of
over
the
the-
learned advocates representing the petitioner and Kolkata Municipal Corporation. Stop. In the writ petition ordered dated 4th August 2014 passed by Chief Manager within bracket personnel bracket close is under challenge, whereby prayer of the petitioner to grant compassionate appointment in view of physical incapacitation of the father of the petitioner who was employee of corporation has been spurned. Stop. Next paragraph. In spite of giving direction by the coordinate bench to file affidavits, no affidavit in opposition has been filed on behalf of corporation. Stop. Mr. Learned advocate representing the corporation has prayed for time to file a report in the form of affidavit. Let such report be filed within 10 days from date with an advance copy upon the learned advocate representing the petitioner. Stop. Next paragraph lists the matter under the heading hearing Group 5 municipality for disposal on ninth October 2020.
My lord, kindly take it up 10th, my lord, 9th is personal difficulties.
My lord,
Kindly take.
since I have to file a report, lordship kindly grant some more time.
Old matter, why you have not filed affidavit?
My lord, I was not appearing. But could it be on the last
12th October
But
2020.
could it be on the
16th October.
16th of, yes, 16th.
16th October 20.
But by that time, I'll file my report. Grateful to your lordship.
107. I have said 10 days, you file your affidavit.
Yes,
You file your reply in the form of affidavit.
yes, report in the form.
Report in the form of affidavit. Right.
Okay.
Next. Till date, your electricity has not been provided to the petitioners.
Not to the petitioners, my lord. Tell your lordship.
No, till date, whether petitioners are not getting electricity. No,
The petitioner, my lord, the petitioner is the municipality.
so you are not the petitioners.
Ah.
Petitioner is the municipality. Now, the electrical poles could not be installed
Could not be installed
till
because,
date.
because
So how the electricity is provided to the to 6 wards as indicated in the in the prayer? Eight
8 wards.
8 wards.
Tell your lordship what has happened, my lord. The municipality, contiguous areas of the municipality was included in the municipality which the land belongs to the railways. Now, my lord, after the areas was incorporated in the municipality, my lord, the 8 wards were extended. Now,
Yes,
8. There were 27 wards, now it becomes 35.
8 wards were added.
Municipal wards, 8 wards were added. Areas were added, that was divided into separate wards, my lord, 8 wards. My lord, the approximately more than 1 lakh people are residing over there in those 8 wards. Now, my lord, as a municipality, my lord, once it has come under the municipal area, my lord, the basic amenities are to be provided by the municipality to the people who are deciding, irrespective of whether the land belongs to the state or the private land or to the government. Now, my lord, basic amenities in terms of section 63 of the Act, my lord, are the electricity, water supply, drainage. These are main. My lord, the municipal, whenever the municipal authorities went there or their workers to do their job, my lord, they were stopped by the railway authority. Now, my lord, we gave a letter to the railway authority that we want to install electric poles to supply the electricity to the people of that area, the added area. No, we didn't get any response. We wrote to the electricity department, WPSCDCL, that you kindly proceed with the installation of the poles for providing electricity to the area. When they started work, my lord, the municipal
Whether the poles are to be installed by the municipality or the supply authority.
WPSCDCL,
Yes.
they started the work. They started the work and the railway authority stopped that. That is the only grievance of the municipality for which we have come before the court. That we are being restrained from providing the basic necessities to the public at large. Though they are the,
If it is the land of the railway and they
we
don't
want,
permit you,
we
what can be
wanted,
done?
Millard, they were sitting.
Then you have to find out alternative route to supply
Can't
electricity.
be, Millard, because the area is a large area. It's not that, suppose Millard, at the municipal area, the added areas, the land belongs to the government. Railway, we are not done. But it extends to a huge area, Millard, where the people residing at the end of the area, Millard, how they can be provided with electricity if they are, if it's required. Millard. The land is required for that, for electing the poles and everything, Millard. Even for the purpose of giving the drinking water, Millard, we have to take the route of the.
Was there any
underground or
direction for
whatever.
filing affidavits by the authorities?
Affidavits have been filed, Millard. There was direction from the court.
Affidavits have been filed. We will then serve notice upon the learned advocate representing the respondents.
Don't speak on those.
As well as West Bengal State Electricity Distribution Company sub notice. Issue. The writ petition is heard in presence of the learned advocate representing Kharagpur municipality. Stop. However, no one is representing the respondent student. Stop. Next paragraph, the learned advocate for the petitioners is directed to serve notice upon the respondents or the learned advocates representing the respondents, including copy of the order passed by this court today by by 6th October 2023. Stop. List the matter for further 6th October 2023 and file affidavit of service. Stop. List the matter under the heading hearing group 5 municipality for disposal on 9th October 2023. Next,
Several meetings were held with the railway authority in terms of.
but issue was not resolved.
No, unless the court intervenes, my lord, I tell you very frankly, my lord, it's a political issue. State versus central government. And because of that, my lord, the people of the area are suffering.
Court need not enter into the political issue. Court will appraise the legal issue as well as a factual issue
Something has to
in
be
order
done.
to decide the
Something has to be done.
in order to
Some-
decide the lease. Next,
Item number 108.
no one appears for the petitioner and no accommodation is paid for. Stop. It appears video order dated 26th August 2015. A coordinate bench directed the parties to exchange affidavit. Stop. Read petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading hearing group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
109 and 110.
issue. You are for the corporation in both the matters.
Yes.
Both the writ petitions are taken up for consideration when no one appears for the petitioners and no accommodation is paid for. Stop. However, Kolkata Municipal Corporation is represented by learned advocates. Stop. Next paragraph, it appears video order dated 16th March 2016. A coordinate bench directed the parties to exchange affidavits. Stop. Writ petitions need to be treated as hearing matters. Stop. Next paragraph lists the matters under the heading hearing Group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clear if on the adjourned date petitioners go unrepresented, consequential order shall be passed. 5th October.
Item number 111.
I'm the petitioner, my lord. This is an order of demolition which was passed by the special officer, my lord. After it was said, it was regularized at that point of time, my lord. All the regularization provision was not there. It was regularized upon payment of some fine, which was stayed by this honorable court. But during the pendency of the writ petition, my lord, those portions have already the private respondents have admitted that those portions have already been demolished by them. Only a small portions of it are remaining, but most of it has already been demolished voluntarily by the private respondent.
You are appearing for the petitioner and private respondent has demolished the portion.
Not everything, but most of it.
Then what is which portion is not demolished, which is left?
Small portions. I can show pictures with my lord.
Why private respondents have demolished that the portion? This is your writ petition.
This is my writ petition.
Who are you? You have constructed or private respondents have constructed?
Private respondent. I am the neighboring. I am a neighbor of the private respondent. The private respondent had constructed the building by making certain deviations from the building rules. If my lord kindly.
So today are you pressing this writ petition or not?
I am setting aside of this order which says that it can be regularized by payment of money. Because
But in view of demolition work carried out by the private respondent, is there anything left?
Some portions are left. Not everything. Most of it may have been demolished, but some portions are still there. And my lord, this order.
Why are you after pound of flesh and drop of blood? From your submission, it appears. First, hear this court. When a major portion has already been demolished, then what remains?
The private respondent, my instruction is that if the private respondent undertakes that they will not.
If you want to hold any conference, do it outside the court in your chamber. During the hearing of this court, first you have to give preference to this court.
I should have.
Don't lay your ears to your junior. Yes.
But I'm pressing the writ petition to the extent of the portions which have not been demolished. But
You want demolition of that portion.
I want demolition, but if the private respondent undertakes that they will not reconstruct the portions they have demolished, then nothing much remains. That is my instruction.
There is a dichotomy in your submission. In one hand, you are saying that the main portion has already been demolished. Now, in the other hand, you are saying that there is a regularization order has been passed.
This is my order, an order of 2009, much prior to the 2015 amendment, which allowed regularization by payment of money. At that point of time, I have judgments of this honorable court, which specifically says that even a minor construction cannot be regularized because it is not part of the 1980 Act. Because
Ghanshyam Das is judge. Yes. Yes.
that is there. So this order and this was my lord passed by a special officer, and there are
So you are challenging. You have challenged this retention or regularization order.
my lord. I've challenged the regulation.
So your contention is this that regularization order is still on record,
My lord. Still on record. This
still
needs to go.
retained on record. So therefore, you want to press this writ petition for setting aside the order of regularization. Was there any direction for filing affidavits?
But affidavits have been filed, my lord.
Filed.
Affidavits are complete, my lord.
Very well, you serve notice upon the private respondents. Today they are not represented.
I will.
And may copy of the writ petition may be served with me so that I can.
Request your learned friend upon payment of cost.
I shall.
Yes, issue. Writ petition is taken up for consideration in presence of the learned advocates representing the petitioner and the Kolkata Municipal Corporation. However, private respondent, however, respondent number 9, 10, and 11 are not represented today. Stop. Next paragraph, the learned advocate for the petitioner is directed to serve notice upon the non-appearing respondents, including copy of the order passed by this court today, and file affidavit today by 6th October 2023 and file affidavit of service on the adjourned date. Stop. List the matter for further consideration under the same heading on 9th October 2022. List the matter for further consideration under the heading hearing group 5 municipality for disposal.
On 5th.
9th.
9th.
112.
Questions. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. List the matter under the heading motion group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clearly from the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
113.
At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. Next paragraph, list the matter under the heading motion group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clearly from the adjourned date petitioners go unrepresented, consequential order shall be passed. Next,
114,
here for the
Mr. Alok Kumar Ghosh is appearing for the
municipality. Issue. At the time of call, no one appears for the parties. However, on perusal of records, it appears that the order passed by the coordinate bench on this writ petition dated 16th February 2018 was set aside by the Honorable Division Bench, video judgment dated 2nd July 2018. Preferred by the added respondent. 18 in the appeal preferred by the added respondent. In the appeal preferred by the added respondent. Stop. The appellate court, while disposing of the appeal being MAT 315 of 2018, directed the learned single judge to decide the writ petition on filing of affidavits. Stop. You are for the corporation? Filing of the affidavit. Stop. Next paragraph, list the writ petition under the heading hearing group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clearly from the adjourned date, petitioner goes unrepresented, consequential order shall be passed. Give your appearance. Please. Now, at the time of call, petitioner is not represented. Stop. However, Kolkata Municipal Corporation is represented by London. Next.
115.
My lord, 115, my lord, we would like to make an application for being added as a party because, my lord, from the lower court proceedings, my lord, it shows that the writ is pending before your lordship. And we are a vital party because
You are vigilant enough. The 2015 writ petition now in
my lord, I am not,
23, you are making a submission for filing an application for being added as a party.
my lord, we came to know from the lower court.
Wrong tenor.
My lord, this matter did not come up before, my lord.
So you are waiting when this writ petition will come up, then you will file an application.
My lord, because the properties in question involved in this matter, my lord, they are wanting to merge this property. The reason why we are required is, my lord, they are going to block the road, my lord, which is there are judgments of this court, my lord, wherein it is guided that this is something where they should not intervene.
My lord, I am if you want to file an application, who prevents you? File an application that will be considered. Without filing an application, why you are entering your evidence? Let the applicant be added as an as additional respondents. Then this court will consider your contention. Who is for the petitioner? You are for
Hon'BLE municipality.
You are for the municipal. At the time of call, no one appears for the petitioners and no accommodation is paid for. However, Hon'BLE municipality is represented by learned advocates. Stop. Next paragraph. List the matter under the heading motion group 5 municipality for disposal on 5th October 2023. Stop. However, it is made clearly from the urgent date, petitioners go unrepresented, consequential order shall be passed. Next.
116.
I'm obliged.
Appearance.
Writ petition is was dismissed for default. Now you have filed an application for restoration. Let this application appear under the heading application on, in the monthly combined list. No.
Because this application is also within time, 26th of April, the matter was dismissed for default and 10th of May I took up the subject.
It is within time. Where is your affidavit of service? In connection with this your restoration application?
Served to my learned signature by hand.
File your affidavit of service.
That is
Because state respondent is there.
Here, my lord,
Issue. At the time of call, Mr. Rai Learned Advocate representing the petitioners submits that the writ petition was dismissed for default. Video order dated 26th April 2023. Stop. But subsequently, an application for recall of the order dated 26th April 2023 was filed, being CAN 1 of 2023. Stop. Let this application appear under the heading quote unquote application in the combined monthly list of October 2023. Stop. Next paragraph. The learned advocate for the applicants is directed to serve a notice upon the non-appearing respondents and file affidavit of service on the urgent date.
great.
Give your appearance. File it. It will be taken up from the combined monthly list. On Fridays, applications are.
Lordship takes. Great.
Yeah.
No. 117.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph lists the matter under the heading Motion Group 5 Municipality for disposal. On 5th October 2023, stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed.
118.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph lists the matter under the heading Motion Group 5 Municipality for disposal. On 5th October 2023, stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Yes.